right, good morning, ladies and gentlemen. Do apologize for the delay, but let's see if we can get this started. Okay. Is courtroom 2 available? Not yet? Okay. Who do we have at ACDC? Deputy? Is the deputy there?
Your
No.
Honor,
Hmm.
the cases at ACDC are Miss Tucker's, I believe, and she's in courtroom two, so we wouldn't be able to handle them until they come online.
Okay. All right. Well, I guess I'm just waiting for courtroom 2 to appear. And Miss Grace, can you call courtroom 2 and just see if everything's okay?
Yes, ma'am.
Thank you. All right, we'll be in brief recess until courtroom 2 chimes in. Thank you.
There are no deputies in there yet. Judge?
I heard you. No deputies there yet, correct?
Correct. The
Okay.
attorney's in there. They answered the phone, but they said nobody's in there yet.
Can they start the Zoom?
I don't know. Let me ask. Hold on.
Okay.
I don't believe they can judge. The code is usually placed in by the deputies.
Okay. All righty. We'll hold. Thank you.
They coming on right now.
Thank you. Miss Grace, you'll be doing the announcements after we've addressed all the cases, okay?
Okay, Judge.
Thank you.
Good morning, Attorney Tucker. We're ready whenever you are.
Thank you. All right, courtroom
Morning,
2.
Your Honor.
Good morning,
I'm
Deputy Milton. Fine, thank
good
you.
morning.
Good
Good,
morning.
thanks.
I'm sorry?
I'm good. How are you doing?
I'm doing well, thank you. I was just waiting for courtroom 2 to chime in. Good morning, Ms. Tucker.
And we're ready with Ms. Washington, Your Honor. Position 39 through 41.
Okay. This is State versus Keandra Washington. Cases, well, first of all, Ms. Washington, I'd like to remind you that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney if you cannot afford one. One will be appointed to represent you. We have 3 cases for Miss Keandra Washington, 25 CR 2629C, 2938C, and 25 CR 6781C. Sorry, I'm trying to get to the right calendar. This is positions. Okay. That didn't work. All right. So, Mr. Scirocco and all other prosecutors, I'm having problems with my printout, so I'm either going to go real slow with reading out the charges, or you can read the charges as you recommend the plea offer. Okay? So I'm going to pick the latter. So with regards to these three cases, Ms. Tucker is going to be your appointed counsel, Ms. Washington. And Ms. Tucker, how are we proceeding with these three cases?
This will be a non-negotiated plea, Your Honor.
All right. So let's start with position 39. And Ms. Washington is charged with simple assault, family violence from May 11th, 2025. What's the state's recommendation?
Good afternoon, Judge. Excuse me, good morning. This case where she is charged with simple assault, family violence, the state's recommendation here is 12 months probation to run consecutive to 25 CR 006781C. No further contact with Alexiani Greer, no firearms, and stay away from 1634 Hollywood Road in Atlanta. This is a global offer with her other two open cases. Would you like it for me to go through the recommendations for each before I get to the facts and argument here, Judge?
Yeah. And with
Okay.
regards to the second case on which one? 2938C. And she's charged with battery, family violence. What's the recommendation?
The state's recommendation for that case, it would be 12 months probation consecutive to 25 CR 002629C. No further contact with Alexiani Greer, no firearms, stay away from 1634 Hollywood Road in Atlanta.
Okay. And the third case?
And on the third case, for count 1, battery, family violence, with counts 2 through 5, battery, family violence, and 3 counts of simple battery, family violence. 2 through 5 would merge with count 1. Count 1 would be
Hang
12
on,
months.
sorry. Which one will merge with count 1?
2 through 5 will all merge with count 1, Judge.
Okay, that makes it easier. All right.
Yep. And count 1, the recommendation there is 12 months, served 250 days, credit for time served, balance probated, FFIP, no further contact with Alexiani Greer, stay away from 1634 Hollywood Road in Atlanta, 80 hours community service, and no firearms. As your Honor might have noticed, the victim's name here is the same in all three of these cases. With the first incident that is position 39, simple assault, family violence, that was from May 11th, 2025. Took place at 1634 Hollywood Road in Atlanta, where the two of them live. They're in a relationship with one another, and they'd been residing together for a year. When law enforcement responded, Miss Greer, the victim here, explained that she was lying in bed. Defendant entered the room, took her phone without her consent, and accused her of infidelity. Then became agitated and began attacking her, striking her multiple times in the face as the victim tried to defend herself while still in bed. The defendant escalated the situation.
Well, I don't need to go through all the fact patterns. I can look them up on the accusations right here. What is it about the latest case that is rendering this a non-negotiated plea?
I believe it's the time to serve and also the fact that we are asking for a total of 36 months probation, Judge, that these would run consecutive to one another. Correct me if I'm wrong, PD Tucker.
Yes, that's correct. For position 40 specifically,
Yes.
the terms that are listed for that consecutive year probation is no further contact and a stay away. So we're asking for the balance to be suspended, which would leave 2 consecutive years of probation for all 3 positions. And we're requesting as well for the time to serve to be 125 days. In total.
On what grounds?
I was asking for the time to serve to be reduced. Ms. Washington does have a hold out of Collier County for a probation case. So she's not going to be released from custody. She'll just be transferred. So we were asking for the reduction so that she's able to transfer to Collier to handle all of her open cases.
And I should note that that Collier County, that appears to be, if that is a probation violation, it's for a battery case, notably. And with the first two cases, Your Honor, I believe they were handled on the same, oh no, well, days apart. She was given a surety bonds by Your Honor, ordered to have no further contact with the victim and stay away from the incident location. And she violated the terms of her bond with respect to both of those conditions in returning back. That the second incident, the second battery family, the first battery family violence, but the second case was she notably beat the victim with a belt, causing, I believe it was bruising, and then I believe that was also a dispute over her phone, and it sounds like a lot of this is linked to infidelity, feelings of infidelity, and she was beat with a belt, causing bruises.
Any feedback from the alleged victim, Alexierne Greer?
We have not heard from her with respect to the plea. We did attempt contact. And with the position 41, that third incident, of violence, the second battery family violence, involved pinning her down as she tried to defend herself and beating her with a belt, causing markings on her back, her right arm, and a cut on her finger that was bleeding. We're very concerned about the victim's safety here. We don't think these two should be around each other for quite some time. With the probation being consecutive, the state, that would allow her time following the sentence to complete the family violence intervention program after she's served that time, and then also would ensure that these two are not anywhere near each other.
No, I
That's
don't
what
think we
we're
can
acting-
guarantee that, Mr. Scirocco, but given this track record, but I get your point. Thank
Yeah.
you. Ms. Tucker, so you want me to reduce the time to serve from 250 days to 125 days. She's going to be given credit for 36 days. Is that correct?
Yes, Your Honor.
Okay. And then and essentially do balance suspended on the incident from, I guess, May of, I'm sorry, yeah, from May of 2025.
Yes, Your Honor.
Okay. And this is two cases from May 11th, 2025, April 6th, 2025, and July 13th, 2025. So three separate incidences involving the same victim, and she's got a probation hold. She's actually got a fugitive hold. I guess it's for the probation violation for another violent charge. And I don't know how old that charge is. Do you?
2024, Judge.
Ms. Tucker?
Well, I don't have the information for the hold in Collier County. It just said, for me, what I can see is the hold out of the foreign county for probation. I'm not sure the nature of the charge.
My concern is in less than 24 months, your client has garnered 4 separate violent cases on her belt. That's
Yeah.
my point.
He's prepared to take responsibility for those.
And I'm glad she will. I'm glad she will because she seriously needs to. I am going to go with the state's recommendation. Unless I have the alleged victim here to give me a different version or a different account, I'm going with the state's recommendation just based on this track record. I think Miss Washington may have some issues that need to be resolved. And hopefully this sentence, if she decides to accept it, may help her move forward.
Ms.
Uh,
Washington, do you want
Yes,
to-
go ahead. Debbie Milton, please unmute. Miss Washington, I am not accepting the defense recommendation. I'm going to require you to complete the 250 days less 36 days at the Fulton County Jail. And then once you're released on probation and once you're released from your probation hold, you will be on probation for up to 3 years with no contact with Ms. Greer and to stay away from the Hollywood Road as well as other conditions. Would you like to accept this plea recommendation or would you like to have your case scheduled for trial?
Well, I spoke to my brother, and he said that I was able to reset. So
I don't understand what you're saying. You need to speak up and
Your Honor, what Ms. Washington is requesting, can we reset this case until next week so she?
no. Today we arraign the case or we take a plea.
Yes, Your Honor.
Would you
yeah,
like to speak to your attorney?
yes, I speak to my attorney.
Definitely. Good thing to do. All right. Miss just sit. Okay, well, all right. I was going to put you all in Miss Tucker, would you be able to call ACDC?
Yes, Your Honor.
All right. Miss Champion, please mute ACDC. Thank you. All right. Good morning, ladies and gentlemen. My name is Judge Lal, and we're going to proceed with this plea and arraignment or state all-purpose calendar. These are cases, misdemeanor criminal cases in which individuals have already been arrested, booked, charged. Their cases have been formally accused by the Solicitor General of Fulton County, and bonds have already been set for these cases. Now, if during this time, if you've had conversations with your attorney, today you will make a decision as to whether you would like to move forward with accepting a plea offer from the prosecutor in exchange for a recommended sentence, or whether you would like to enter a plea of not guilty and have your case further notice for a bench trial or a jury trial. During the course of these proceedings, please remember that you have a right to remain silent. Anything that you say in open court, your statements can and will be used against you in the treatment of your case. You have a right to an attorney. If you cannot afford one, one should have already been appointed to represent you, and you should already have had a chance to speak with him or her with regards to whatever recommendation the state is giving or whatever is the outcome of your discussion with your attorney. All right, Mr. Mirzadjadin, who do you have next to you?
We have position number 5, Mr. Banks.
Okay, and how are we proceeding?
Negotiate a plea, Judge.
All right. I'm
Judge.
sorry, folks, I'm going a little blind, and so I'm counting on my litigation manager and counsel to just give me a heads up what's going on in terms of how your clients would like to move forward. Okay, so Tony Banks' case is 25 CR 6669E. Mr. Banks is accused of one count of theft by shoplifting, one count of criminal trespass, and a $250 cash bond was provided in this case. Mr. Banks, you've been advised of your rights, and your attorney is Mr. White. May I place you under oath for the plea? Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, I do, Judge.
I'm sorry?
Yes, I do, Judge.
Okay, I think he said yes, Judge. Okay.
Yes, I do, Judge.
All right. Okay, Ms. Spear, good morning. And what's your
morning, Your Honor.
recommendation for Mr. Banks?
On the theft by shoplifting, the state recommends 12 months probation, serve 45 days, credit for time already served, the bounds probated, an anti-theft course, 20 hours of community service, stay away from all Walmarts, not just the one at 844 Cleveland Avenue, a BHET, and for the criminal trespass, 12 months probation to run concurrently to count 1.
Mr. White?
Yes, Your Honor, we accept the plea as negotiated and allows probation to terminate or go non-reporting once he completes all of his requirements.
Not with his history. So he'll be reporting every month. And he'll need to get a job and start paying probation fees. Would you like to accept that recommendation?
Judge, we've already yes, we would accept him.
Okay. Mr. Banks, have you consumed any medicine or alcohol recently?
I take medication for mental health.
I'm sorry, I didn't understand the response. You did what now?
No, I haven't consumed alcohol.
All right. So was there a yes, you consumed some medicine?
Yes.
All right. And after you consumed your medicine, are you still able to understand what you and your attorney discussed?
Yes, ma'am.
And do you understand what's going on in your case?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, but can I offer 6 to 8 months probation due to me never being on probation in Fulton County?
Well, if you can't be on probation, active probation, then we'll just reschedule your case for trial.
I'll take the probation.
You do what?
I'll take the probation.
All right. And if you decide to be on probation, you'll be required to report once a month, pay your probation fees, do community service, as well as a behavioral health evaluation, and you are not allowed to shop at any Walmart store or enter a Walmart shop. Are you comfortable with doing all that?
Yes, ma'am, but can you go for 8 months probation instead of 12?
No, I would do 24 months probation, but I have to settle for 12.
All right, you know what the fees would be for the probation?
About $50 a month.
Yes, ma'am.
And sorry, so with regards to all these conditions, you're comfortable with that? So let me ask you, if you decide to plead guilty to these charges, you would have to give up your right to a trial. You won't go back to a courtroom to face your accusers. You won't be able to challenge the charges in a court of law, be able to present your arguments and defenses, and the prosecutor won't have to carry her burden and prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of theft by shoplifting from October 23rd of this year?
Plead guilty.
How do you plead to criminal trespass at the Walmart on Cleveland Avenue in October of this year?
Plead guilty.
Your sentence for the shoplifting is going to be 12 months to serve 45 days. You're going to be given credit for, 16 days?
I show 22 as of last week.
Okay.
Be 28 or 29 today.
He has 28 days, so he'll be given credit for 28 days. And then once he is released, I don't see any holds. So he will report to Fulton County Probation in person on Monday before 3 p.m. at 132 Mitchell Street. He will then continue to report to probation every month and be current with his probation fees. He'll be required to do 20 hours of community service, and he'll need to do that at any nonprofit agency at a minimum rate of 5 hours per month. He will stay away from all Walmart stores in the entire state of Georgia, including the one at 844 Cleveland Avenue. Within 30 days, he will seek out a healthcare provider and undergo a behavioral health evaluation and submit himself to any and all treatment. He will be compliant with all treatment and medication that is currently prescribed to him. For the criminal trespass, that will be 12 months concurrent with count 1. Thank you, Mr. Banks. Next case.
We go to position number 10, Mr. Clerk.
Christopher Clerk.
It's a negotiated plea.
Thank you, Mr. White. Christopher Clerk is accused of theft by shoplifting and criminal trespass from November 7th of this year, and he is currently in custody on a $2,500 good bond. Mr. White, excuse me, Mr. Clerk, you've been advised of your rights, and your attorney is Mr. White. May I place you under oath for your plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. And Ms. Spear, your recommendation?
Yes, Your Honor. On count one, theft by shoplifting, the state recommends 3 months probation, serve 30 days with any credit for time already served, the balance probated, an anti-theft course, stay away from the target at 3535 Peachtree Road. For the criminal trespass, we're asking for 12 months probation to run concurrent.
Okay, I'm a little confused. So you were saying 3 months probation for the theft by shoplifting and to serve 30 days.
12 months
Okay.
probation, serve 30
Oh,
days.
it's 12 months. I thought I heard you say 3. Okay, no
I
problem.
apologize, Your Honor.
That's okay. Thank you. All right. Mr. White, are these the terms to which your client has agreed?
Yes, Your Honor.
And do you stipulate to the factual basis, venue, and ID?
We do for the purposes of the plea.
All right. Mr. Clark, have you consumed any medicine or alcohol recently?
No, I don't know.
And have you understood what's going on in your case?
I don't have no attorney.
I'm sorry, I don't know whether Mr. Clark is responding or whether I'm hearing the background conversations.
Yes,
So-
he's informed me of everything.
Mr. Clark, are you satisfied with the legal services you have received?
Yes, ma'am, I am.
Okay, and if you have it's been explained to you that if you accept this plea offer, this will be a conviction of theft by shoplifting on your record. And if you have 3 or more theft by shoplifting convictions, any subsequent arrests for this charge will be a felony charge.
Yes, I'm.
Okay? Are you entering this plea freely, willingly, and knowingly?
Yes, I am.
So it has been explained to you that if you take this plea, you would have to give up your right to a trial. You will not be going back into a court of law to face your accuser, to be able to challenge evidence brought against you, present your own legal arguments and defenses, and the state won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, I am.
How do you plead to 1 count of theft by shoplifting and 1 count of criminal trespass?
I plead,
I can't hear a word you're saying.
I plead guilty.
All right, I heard guilty to both charges. Is that correct, Mr. White?
Yes, Your Honor.
Okay. On the theft by shoplifting, the sentence is 12 months to serve 30 days, credit for time served. The remainder of the time he'll be on probation. He will report to probation on Monday before 3 p.m. While he's on probation, he will complete an anti-theft class and he will stay away from the Target store at 3135 Peachtree Road. For the criminal trespass, the sentence is going to be 12 months probation, concurrent with count 1. He will report to probation every month until he has completed the anti-theft class. And if he is current on his probation fees and he hasn't violated any more laws, then his probation will be non-reporting. Thank you.
Thank you, Your Honor.
Next, we'll go position 16, Rolando Hill. Ms. Hill?
Negotiated plea, Judge.
Thank you. Philandro Enrique Hill, case number is 25 CR 7130A, accused of criminal trespass and willful obstruction of an officer. Mr. Hill, you've been advised of your rights and your attorney is Mr. White. May I place you under oath?
Yeah, that's
Do you solemnly swear the testimony you provide will be the truth to the best of your knowledge?
yes, ma'am.
Ms. Spear?
Yes, Your Honor. On the criminal trespass, the state recommends 12 months probation, credit for time served, 20 hours of community service, stay away from the Millworks Apartments at 1888 Emery Street Northwest. On count 2, willful obstruction, we are asking for time served. I show 10 days served as of the 14th, so it may be closer to 16 days. Mr. White might know better than I do. Oh, and we do ask for a stipulation to ID venue and facts and circumstances.
So stipulated, Your Honor, for the purpose of the plea, and concur with the state. It's time. It's about 16 days.
I don't have a complaint. I did not.
Oh. We're just, there's nothing that you need to say at this point. We're just discussing the time that you've done in jail.
Mr. Hill, have you consumed any medicine or alcohol recently?
No, I haven't.
Are you satisfied with your attorney?
Not yet till I get my freedom papers and I get obstruction taken away from the conviction on the pieces of paper. From
So
arrest.
that was a no. You are not satisfied with your legal services.
I am not certified till I'm released.
Okay. And have you understood what is going on at the present time?
Yes, I'm in court right now.
Okay. And do you understand what decision you're making today?
Yes, to be released on time served and not probation, because time served means I would not need probation because I would like to work a job and I didn't run from the police.
Okay. Mr. White, I cannot accept this plea and we can arraign this case, or you can file a waiver of arraignment. What would you like to do?
Can I have 30 seconds with him?
You may have, yeah, certainly.
Bill, like we talked about yesterday, you will be on probation just to do 20 hours of community service. That's all the requirements you have while on probation. Obviously, the remainder of the sentence, you have to stay away from that apartment. You agree to this? Are you saying you don't want to do the community service anymore?
Nah, that's fine. The way that you explained it, I completely understand it. And I believe in following instructions, so I like it explained.
Okay, Judge, I think we're okay to go forward.
Let me try again. Mr. Hill, have you understood what's going on in your case?
Yes, I'm mourning my family members. I haven't seen them in over a year and a half, almost 2 years.
That is not what I asked you. I just simply asked you whether you understand what is going on in your case.
Yes, I understand. I've been lied on, and I'm glad that I got a good plea.
You have been speaking with Public Defense Attorney Tom White about the recommendation from the prosecutor in exchange for a guilty plea to these charges. Are you satisfied with the terms and the conditions of the plea?
Is it freedom, right? Freedom today?
You will be released within 24 hours, as we discussed yesterday.
I agree.
But you will be on probation.
Okay. I do have a question. Tom White, does that mean I can't work a job still?
No, you can still work a job.
Sound-
Still service in your spare time.
And you cannot return to the Millwork Apartments at all. You have to stay 200 yards away from the Millwork Apartments, the entire complex. Are you prepared to accept that?
Yes, ma'am.
Are you satisfied with the work that Mr. White has done for you?
I am.
And if you decide to plead guilty, you would have to give up your right to a trial. You will not go back to a courtroom to face your accuser, challenge the evidence brought against you, and the prosecutor won't have to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
I would not like to give up my rights.
What she's saying is that you have to give up your rights to a trial for this case only. You're not giving up any rights going forward, but for this case, you have to give up your right to a trial to enter a guilty plea.
Sure.
How do you plead to theft by, to criminal trespass at the Millwork Apartments?
Yeah, I agree with the terms of state.
You have to say guilty or not guilty.
Yes, sure.
How do you plead to willful obstruction of a law enforcement officer?
That's actually a lie. I'd like to fight that later on, I believe.
I think you should fight that. I think
You-
you should go to trial. The plea is denied, and this case is going to be further notice for trial. Mr. White, would you like me to arraign the case, or would you like to file a waiver?
I'll file a waiver, Judge.
All right. Mr. Hill, I think you should get the opportunity to fight these charges in a court of law, and I would like you to exercise your constitutional rights and present your legal arguments and defenses. All right?
Okay.
This case is going to be further notice for trial, jail jury, and highly recommend that we have a social worker visit. And the waiver will be filed by Mr. White. Thank you.
Okay. Thank you.
Next, we'll go position number 17, Mr. Ivy.
At this point, that's a negotiated plea, Judge.
All right, sounds good. This is State versus Zion Gregory Ivy. His case number is 25 CRC 6769G. Mr. Ivy is accused of theft by shoplifting from October 27, 2025. You've been advised of your rights, and your attorney is Mr. White. May I place you under oath, Mr. Ivy? Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? You need to speak up, sir.
Yeah.
This is taking an oath for purposes of the plea only.
Yes.
Okay. Ms. Spear?
Yes, Your Honor. State recommends 12 months probation, serve 78 days, credit for any time already served, stay away from the target at 3660 Marketplace Boulevard, and an anti-theft course. And we do ask for stipulation for ID venue and factual basis.
Mr. White?
We so stipulate for the purposes of the plea, Judge. We just ask that the probation terminator go non-reporting once he completes his anti-theft course.
Mr. Ivy, have you consumed any medicine or alcohol recently?
Yes.
And are you still, what did you consume? Medicine?
For the topic thing you're talking about now, toothbrush. Because the answer is no.
I'm not asking what medicine you consumed. I asked after consuming it, did you consume medicine or alcohol?
No, I didn't consume any alcohol since I got.
Okay. Have you consumed any medicine? It's either yes or no. In the last 24 hours, did you take any medication?
Yeah, I took one.
Okay. And are you still able to understand what's going on in your case?
Yes.
Why are you here today? Why are you here today?
By shoplifting.
Repeat?
You said my shoplifting.
For shoplifting. Okay. Mr. Ivy, are you satisfied with your attorney?
Yes.
And has it been explained to you that if you plead guilty to the shoplifting charge, you will have to give up your right to a trial in front of a judge or a jury? You will not be able to go back to court to face your accuser, to challenge the evidence that the prosecutor will bring against you, to be able to present your arguments and defenses. And the prosecutor won't have to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to one count of theft by shoplifting? Your sentence is 12 months to serve 78 days credit for time served. Once you have completed the 78 days, you will be placed on probation within 48 hours of being released. You will need to complete an anti-theft class within 90 days of being released, and at all times, you're to stay away from the Target store and on Market Boulevard. If you return to that location, or if you violate any provisions of the law, you could have your probation revoked and end up spending the rest of the 12 months in jail. Do you understand?
Yes.
Thank you.
Thank you, Your Honor.
Next, we'll go with position 15, Mr. Joseph Harbor.
It's also a negotiated plea, Your Honor.
Joseph Harbor's case is 25 CR 7128C. Mr. Harbor, you've been advised of your rights, and your attorney is Mr. White. You're accused of theft by taking, and may I place you under oath for the plea? Do you
Yes,
solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
yes,
Thank you. Mr. Spear?
Yes, Your Honor. We are asking for 12 months probation, serve 30 days, credit for any time already served. Stay away from the Popeyes at 683 Boulevard Northeast. No further contact with the victim, Derek Hickson, and a restitution amount of $150 to Mr. Hickson.
Popeyes on Boulevard. Okay. Mr. White, do you so stipulate?
Do stipulate for the purposes of the plea, Judge, to assess the probation terminator non-reporting once he completes his requirements.
Mr. Harbor, have you consumed any medicine or alcohol recently?
No, I have not, Your Honor.
Thank you. And have you understood what's going on in your case?
Yes, I understand that I'm being released today for time served. Is that correct?
Mr. Harper, as we discussed yesterday, it is a time served plea as far as the amount of time you've done at this point, but it could take you up to 24 hours to be released. It may be tomorrow morning before you're actually out.
Okay, thank you.
Uh-huh.
You understand that you're pleading guilty to a criminal offense today?
Yes, Your Honor, I understand that. I pled guilty with my lawyer yesterday.
And you understand that you'll be placed on probation where you'll be required to report every month?
Yes, I understand that.
Are you satisfied with your attorney?
Yes, I'm very satisfied with my attorney.
If you decide to plead guilty to this charge of theft by taking, you would have to give up your right to a trial. You will not go back to a courtroom to face a judge and a jury. You will not be able to confront your accuser, challenge the evidence brought against you, and the prosecutor won't have to carry her burden to prove the charge beyond a reasonable doubt. Are
Yes.
you prepared to give up these rights? Are you prepared to give up these rights?
Yes.
How do you plead to theft by taking?
Guilty.
Sentence is 12 months to serve 30 days, credit for time served 15 days, balance probated. As your attorney indicated, you will be released within 24 hours. So, but on Monday, this coming Monday, you will report to Fulton County Probation before 3 p.m. While you're on probation, you will stay 200 yards away from the Popeyes restaurant at the corner of, I think is Boulevard and Ponce de Leon Avenue, if I'm not mistaken. You know exactly where that is?
Yes, Your Honor.
All right. 200 yards is the length of 2 football fields. So you can't even be near that whole intersection. Understood?
Yes, Your Honor.
All right. You're also to stay away from Derek Hitchen, who is the victim from this particular incident. You're not to communicate or contact him in any way and stay 200 yards away from him. You're also to pay back $150 of restitution, and those payments will be made directly to your probation officer. You must make the payments complete all $150 within the first 8 months of probation. You report every month, and if you have completed your payments for restitution, if you have not violated any laws and you're up to date with your probation fees, then your probation will be non-reporting. Thank you.
Thank you, Your Honor.
Mhm.
We'll go with, position number 12, Mr. Eggleston.
I need to speak with Mr. Eggleston.
All right, next case then.
You can call.
I can call, okay, you have, you have Wiley. Position number, let me get the position number, I'm sorry. 43, Mr. Wiley.
Okay. And by the way, Ms. Tucker, have you completed your discussions with Ms. Washington?
Yes, Your Honor, I have spoken with her.
And how are we proceeding?
I believe it's going to be a waiver. She did indicate that I do need to speak with her again, Your Honor.
Okay, that's fine. State versus Kamar Wiley, case number 25 CR 7133J. He's accused of criminal trespass from November 6th of this year. Mr. Wiley, you've been advised of your rights. Ms. Tucker is your attorney. And how are we proceeding, Ms. Tucker?
This will be a negotiated plea, Your Honor.
And I'm sorry, I'm having printer issues, so I'm counting on counsel to let me know. This is a negotiated plea. Mr. Wiley, may I place you under oath for the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. And Mr. Scirocco, what are the terms of your recommendation?
Yes, Your Honor. For the criminal trespass, the state's recommendation is 12 months served 30 days, credit for time served, balance probated, undergo behavioral health evaluation and any recommended treatment. Stay away from the IKEA located at 441 16th Street in Atlanta. And 20 hours community service. We would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea.
And I'm sorry, what kind of evaluation?
Behavioral health.
Okay. Ms. Tucker, do you so stipulate?
We do so stipulate for the purpose of the plea, Your Honor. And we will request that once he completes the terms, that probation go non-reporting.
Okay, so.
He's already on another active probation in 25 CR 6218J. So I'm going to require him to continue probation on both cases actively and complete them without any non-reporting provisions.
Yes, Your Honor.
Would he still like to proceed?
Yes, Your Honor.
Okay. Mr. Wiley, have you consumed any medicine or alcohol recently?
No.
Have you understood what's going on in your case?
Yes.
And are you satisfied with your legal services?
Yes.
If you decide to plead guilty to this charge, you would have to give up your right to a trial. You will not be able to go back to a courtroom to face a judge or a jury, face your accuser, challenge evidence that will be brought before you, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to one count of criminal trespass at IKEA?
Guilty.
Your sentence is 12 months to serve 30 days, credit for time served. Once you're released, you're to report to probation on Monday before 3 p.m. And while you're on active probation for this case, as well as your other prior case, you will continue to report once a month and be up to date with your probation fees. Within 30 days, you will undergo a behavioral health and subject yourself to an evaluation and treatment. You're to stay 200 yards away from the IKEA located on 16th Street in Atlanta, Georgia. And you're to complete 20 hours of community service, which means that you will have to do the community service at any nonprofit agency that isn't a church or a school. And you must do your community service at a minimum rate of 5 hours per month. So looks like on his other probation case, 25 CR 6218J, he's already required to complete a BHET, an MHET, I don't think community service was included. Okay. So, Mr. Wiley, if you have not completed a behavioral health in your prior probation case, you need to do one for this case, and I will accept it as a evaluation treatment for your prior probation as well. Do you understand? You don't have to do it twice. But if they recommend treatment and counseling or medication, you would have to comply. Understood?
I understand.
All right. Anything else, Ms. Tucker?
Nothing further, Your Honor.
All right, thank you. And he will be reporting every month. Thank you. All right, going back to Miss Washington's 3 cases, 39, 40, and 41. Ms. Tucker, you still need to speak to Miss Washington?
Ms. Washington, did you want to proceed with the plea or go to trial?
I'm here. Sorry.
Miss Washington, have you made a decision?
I'm here. I'm sorry. Excuse me.
We're not asking for you, Miss Greer. If you want to participate, you need your video on and your audio off. Thank you. Miss Washington.
Just speak loud.
Your Honor, I believe that this is the victim in the case.
I know it is the victim, but I need to know your client's decision.
Me and Ms. Tucker haven't really had enough time to.
Honor, can we readdress this case, this position? So I can give another call to ACDC.
Okay.
Thank you.
Ms. Guerra, please switch your video off and we'll come back to it when Miss Washington comes back on. Courtroom 2, next case.
You better get on the phone.
I think so.
Okay. You can go to Mr. Powell.
Give me.
Oh, man.
That was Mr. Powell.
Yes, ma'am. Roderick Powell, position.
Okay. Roderick Powell is position 32, case 25 CR 7184D. Who represents Mr. Powell?
That'd be Attorney Abraham Ahmed.
Oh, Mr. Ahmed, sorry. Have I been calling you Mr. Marsajadin? I apologize.
Just once, Your Honor, it's okay.
I'll get your name right in a couple of months, I promise. Okay. All right. And and this is going to be a plea, Mr. Ahmed?
Your Honor, it would be a non-negotiated plea.
Okay. Mr. Powell, you've been advised of your rights, and your attorney is Mr. Ahmed, and your charges are 2 counts of simple battery from November 6, 2025. May I place you under oath for the plea?
Yes, ma'am.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Mr. Scirocco, 2 counts of simple battery. What's the state's recommendation?
Yes, Your Honor. This was the November 6th incident, wherein it took place at the Juanita H. Gardner Senior Community at 3650 Bakers Ferry Road in Atlanta. There was a tenant causing a disturbance with the leasing office. Officer made contact with victims Antonisha Smith and Mamie Cobb. Ms. Smith, assistant manager for that community, explained that the defendant resident was a stranger to her. And when she arrived at work, the defendant was making a mess in the common area, approached the defendant, politely requested he clean up the mess, and was met with hostility, became increasingly mad and hurling insults at her, then aggressively grabbed the back of her jacket and threatened to spit in her face. She felt cornered and threatened, and she insisted he release her grip. He refused to comply, at which point she had to push him away, at which point he fled down the hallway. Mamie Cobb recounted her own experience with the defendant, wherein the defendant grabbed her by her jacket and slung her against the wall. Both of the victims here reported feeling endangered and called the police. And defendant was ultimately apprehended down the road. State's recommendation, given what I'm seeing is a 2020 ag assault conviction, 36 cycles. It looks like there's an open battery family violence out of DeKalb from this year, I believe just 2 months ago. Prior arrest for aggravated assault, 2017. Prior arrest for simple battery, 2003. And there's other convictions, disorderly conduct, 2018, and criminal trespass, NOLO, 2018. State's recommendation is 12 months on the first simple battery, 12 months, served 60 days, credit for time served, balance probated, no further contact with Antoinisha Smith, 12 weeks, anger management, stay away from Juanita H. Gardner Senior Community at 3650 Baker Ferry Road, and 40 hours community service. And with count 2, 12 months probation, concurrent to count 1, no further contact with Mamie Cobb. We would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea. And if we could sound for Miss Cobb and Miss Smith.
All right. And Mr. Scirocco, if anything else will break down today, it will be my pen. So could you please repeat this recommendation again?
Of course, Your Honor. Sorry, I went.
Simple
You
battery
told me
or-
before I went too
I'm
fast.
sorry, it's 12. I didn't want to break your rhythm. 12
Count 1,
months to serve how many days?
60, Your Honor, with credit for time served.
served. He's only
Balance.
got, okay, balance probated. What else?
No further contact with Antoinisha Smith.
And the 2 victims, Mamie Cobb, and stay away from the 3650 Bakers Ferry Road. Anything else that you require him to do?
Yes, we were asking for 12 weeks anger management and
That
40
was what
hours
I
community
said.
service.
And how many hours, sorry?
40, Judge.
40, okay. And count 2 is 12 months concurrent with count 1 or merges?
Concurrent with count 1, no further contact with Mamie Cobb, Your Honor.
All right, got it. Thank you. Sorry about that, Mr. Ahmed. I just want to make sure I got all the terms down. And what is your attorney, is your client inclined to accept these terms?
No, Your Honor, specifically on the grounds of the stay away, as this is where Mr. Powell lives and needs the treatment of, the healthcare facility and assisted living, as well as the problem with serving time in custody, Your Honor.
Has the assisted living facility indicated that he's welcome back? I don't see anyone who's here from the facility. This is Miss Antoinisha Smith, according to the state, that's the assistant manager.
Your Honor, I don't believe anybody's currently present, but my client has indicated to me that one of the other managers, I believe, Precious, who's the main manager of the facility, would be welcoming him back. We don't have her here, Your Honor.
And what's her name?
What's her last name?
Or his name?
Precious Crouch.
Precious Crouch. All right. Has the state been in touch with the facility?
We have not, Judge. I know we've made attempts at contact, but we have not spoken with Precious Crouch. And we made attempts at contacting Miss Smith and Miss Cobb.
No response.
No, Judge.
Okay. Mr. Ahmed, I'm not certain if I can allow him to return back to the facility unless we have express written permission from Precious Crouch or Miss Smith. Since these 2 individuals work and or reside at the facility, it would be very difficult because Mr. Powell will be required to stay 200 yards away from them, and not be in the same facility with them. So that is the concern. I don't have anything from the facility to indicate that he's allowed back at that location.
Yes, Your Honor.
Would he like to proceed with the plea, or we can wait for Precious Crouch to come back next week?
Your Honor, is it okay for next week? Can we do next week?
I'm sorry, you're muted, Mr. Ahmed.
Yes, Your Honor. We would just like to wait till next week to have an opportunity to contact Ms. Crouch.
All right. We're going to reset this case to Today's the 20th, so it'll be, well, it won't be next week, but that is Thanksgiving Day, so it'll be 2 weeks out.
Could we get it on Tuesday?
I don't know what the calendar is like on Tuesday. Miss Champion or Miss Grace, would you be able to let me know?
Your Honor, Tuesday we have 47 cases.
No, it'll have to be Thursday. Thursday would be December 4th.
Yes, ma'am.
All right, Mr. Ahmed, it's reset to December 4th.
Yes, Your Honor.
And this is a recommendation of 12 months to serve 60 days. So if he's there for additional time, he will be given credit for the time served. And this counts of the state would have to produce either one of the managers or someone who can represent the facility to indicate whether Mr. Powell has a right to return to that assisted living facility.
Yes, Your Honor. Thank you.
Thank you. And of course, Mr. Ahmed, have your client get in touch with Ms. Crouch, who should show up on Zoom to
Yes,
confirm what he's saying. Thank you. All right, next case.
No,
Yeah.
can you do one of my cases of the
Sure. Okay. Your Honor, we can go to position 48, Mr. Nguyen.
Okay. This is State versus Marcavius Wynn. 25 CR 1106C, accused of criminal trespass and causing damage to property and criminal trespass. Mr. Nguyen, you've been advised of your right to remain silent. Ms. Tucker is your counsel. And Ms. Tucker, is this a plea as well?
Yes, Your Honor, this will be a negotiated plea.
Okay, thank you. Mr. Nguyen, please raise your right hand for the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Yes or no?
Yes.
Thank you. All right, Mr. Scirocco?
Yes, Your Honor. The state's recommendation for this on count 1 is 12 months served, 60 days, credit for time served, balance probated, BHET, no further contact with Nina Berry, restitution to Miss Berry, open for 30 days. We did speak to Miss Berry previously. We're waiting on documentation. In her estimate, it's around $500, the amount of the damage, but we're looking for those written estimates there. And for count 2, 12 months probation concurrent with count 1, stay away from Municipal Market at 2209 Edgewood Avenue in Atlanta. At this time, we'd like to sound for Miss Berry, and we would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea.
All right. Nina Berry? Not here. Ms. Tucker, and do you so stipulate, and does your client accept these terms?
We do so stipulate for the purpose of the plea, Mr. Nguyen is acceptable to the terms. We just ask that once the restitution is submitted and paid and he has his eval, that probation go non-reporting.
No objection, Judge.
All right. Mr. Nguyen, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in your case?
Yes, no. Yes, ma'am.
Did you understand what's going on in your case?
Yes, ma'am.
Much better. And are you satisfied with your attorney?
Yes, ma'am.
If you decide to plead guilty to these 2 charges, you would have to give up your right to a trial. You will not go back to a courtroom to face a judge or jury as well as your accuser. and your state won't have to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
It just means you're not going to trial. You're okay with that?
Yes, ma'am.
How do you plead to one count of criminal trespass causing damage to property and one count of criminal trespass?
Guilty or not guilty? What do you plead? Do you want to accept your plea? Okay. Go ahead, tell the judge.
Guilty.
Repeat.
Guilty.
For the criminal trespass causing damage to property, your sentence is going to be 12 months to serve 60 days, credit for time served, balance probated. Once you have completed your time at the jail, you will then report to the Fulton County Probation within 48 hours of being released. While you are released, you will undergo a behavioral health and evaluation with a qualified healthcare provider and submit to all treatment and counseling and medication. You are to have no contact with Nina Berry. You have to stay away from the municipal market, and you are to pay Miss Berry restitution of up to $500. The figure will be determined within the next 30 days. If no figure is provided within the next 30 days, then you will not be required to pay any restitution. However, if there are damages that are submitted and they are capped at $500, you will need to make your restitution payment directly to your probation officer at a minimum rate of $50 per month. For count 2, criminal trespass, your sentence is 12 months concurrent with count 1, and you are to stay away from the municipal market. Thank you.
Thank you.
Oh, and if he finishes his restitution, his evaluation and treatment, it doesn't violate any laws and up to date with his probation fees, his probation will be non-reporting. Thank you.
Right, we can go to positions 46 and 47, Mr. Witter.
And while he's coming up, Judge, I did want to make an announcement that the 2 cases that we asked for resets for felony transfer requests, both of those have been accepted by the DAs. It's position 11, Tyon Daniel, and position 18, it is Mr. Julian Jackson. Both of those were accepted, and I've sent transfer orders to the court, Your Honor.
All right, thank you. Miss Grace, did you make a note of that?
Yes, ma'am. 12, 11, and 18.
11 and 18, transferred to felony court. Thank you. Kyle Brendan Witter has 2 separate cases. One is 25 CR 004346J, and the other one is a bench warrant 25 FTA 2187. With regards to the underlying case, is that correct, Ms. Tucker? You have Kyle Brendan Witter?
Yes,
Witter?
Your Honor.
Okay. With regards to the underlying case, the charge is criminal trespass from July 30th, 2025. Mr. Witter, you've been advised of your rights. Your attorney is Ms. Tucker. And is this going to be a plea?
Yes, Your Honor, this will be a negotiated plea.
All right. Please raise your right hand, Mr. Witter, for the plea. Do you solemnly swear the testimony you provide will be the truth to the best of your knowledge?
It will be the truth to the best of my knowledge. Okay.
Just say yes or no.
Yes.
Thank you. Mr. Scirocco, what's the recommendation for the criminal trespass charge?
State's recommendation is 12 months served 28 days, credit for time served, balance probated, stay away from all Georgia Tech premises and property, and 20 hours community service. Upon acceptance of the plea, the state will null pros position 47, the FTA, and we do not object to non-reporting upon completion of the community service.
All right, thank you.
Would defense stipulate the factual basis, venue, and ID for purposes of the plea?
We do so stipulate for the purpose of the plea, Your Honor, and it is our request to go non-reporting after the terms are complete.
Okay. Mr. Witter, have you consumed any medicine or alcohol recently?
No.
Have you understood what's going on in your case?
Yes.
And are you satisfied with your attorney?
I'm satisfied. Yes, I am.
If you decide to plead guilty to this criminal trespass charge, you would be required to comply with the conditions, in addition to giving up your constitutional rights, which is the right to a trial before a judge or a jury, the right to face your accuser, to challenge the evidence brought against you, present your own arguments and defenses, and have the state prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes,
How do you plead to criminal trespass?
guilty.
Your sentence is going to be 12 months to serve 28 days, credit for time served, I gather 14 days. Would that be accurate?
Yes, Your Honor.
All right, so he'll be released within 24 hours unless he has any other holds. But if not, he reports to probation on Monday before 3 p.m. While on probation, he will complete 20 hours of community service with any nonprofit agency that's not a church and not a school. And he will do the community service at a minimum rate of 5 hours per month. He is to stay away from all Georgia Tech property. He's to stay away from all property belonging to Georgia Tech or the Institute of Technology of Georgia. And if he completes his community service, he doesn't violate any further laws, and he's up to date with his probation fees, then his probation will be non-reporting. Did you have a question, Mr. Witter, about your sentence?
I wanted to know what.
He was asking, he said he thought it was 20 hours of community service. I did confirm, I think he just misheard you.
Oh, sorry. Yes, it's 20. And you have to do it at a minimum rate of 5 hours per month. That means each month you must report that you have completed at least 5 hours. You don't get to put it off to the end of the year.
Until it's finished?
Yes, you can do it sooner than that, but at minimum, it's 5 hours a month. But you can do the 20 hours sooner.
Okay? And the bench warrant is null pros. Thank you.
Alright, good.
All right. Ms. Tucker, any announcement for Ms. Washington? Deputy Milton's waiting patiently with her.
Ms. Washington, do you want to proceed with the plea or do you want to go to trial?
Honestly, Your Honor, I'm not satisfied with my attorney. I wanted another attorney. If I'm not accepting or understanding fully everything, I don't want to proceed without fully knowing everything legally that I need to do. I don't know. So I don't know. I don't know what else to do.
If you want the public defender's office, okay. So if you're not comfortable with Ms. Tucker's representation and you want to get a better idea of what, or if you want to get another attorney to explain what your options and your are available to you, then you need to let me know whether you want to voluntarily terminate the services of the public defender's office.
I mean,
I'll tell you what your options are for attorney. You have a right to an attorney. If you cannot afford one, we will appoint a public defense attorney to represent you. Currently, it's Ms. Tucker. All right? You don't get to pick and choose which attorney you want from the public defender's office. They are a government law firm. They're not a private law firm. Do you understand?
Yes.
Okay. So right now, Ms. Tucker is your attorney. You can decline the services of the public defender's office, and I'll allow them to withdraw. And then you can hire your own attorney. And then we can talk with you and your hired attorney at the next court date, which will be December 4th. Otherwise, you can represent yourself, assuming that you understand the legal laws and the procedures as to how they apply to the facts of your case. Today, I just need to know, what do you want to do in terms of your attorney, Ms. Tucker?
I'm not sure.
I'm sorry?
I'm not sure. I don't understand like
Okay.
what I'm supposed to be doing.
All right. Miss Tucker, this is going to be I'm going to arraign the case, and then she can either hire an attorney or continue with the public defender's office and speak further with the public defender's office to decide how she'd like to proceed.
Yes, Your Honor.
Okay, Miss Washington, I've already read the case numbers that have been brought against you. Do you recall?
They got a simple assault battery. It's 2 batteries.
Let me go into that again, please. Hang on.
Your Honor, the internet is unstable over here, so you're going in and out.
I'm so sorry. Let me see if I can fix that.
It might be over here, I'm not sure, Your Honor.
Can you hear me all right?
Yeah, now I can.
Okay. What were those position numbers again? I thought it was 39, 40, and 41, correct?
That is correct, Judge.
All right, Miss Washington, please listen very carefully. You are charged with simple assault, family violence involving Alex Greer from May 11th, 2025, case number 25 CR 2629C. Do you understand? Repeat.
Yes.
You are charged with battery, family violence on May 11th, 2025 incident for case number 25, same date incident involving Alex Greer in case number 25 CR 2938C. Do you understand?
I'm sorry, Judge, you're breaking up real bad.
Jeffrey Milton, can you hear me? Yeah, please don't leave her side until I've completed. Miss Washington, did you hear the first case?
Yeah, I heard the first one. I didn't get the second one.
The second case is battery, family violence from May 11th, 2025, case 25 CR 2938C. Do you understand? Do you understand?
Yes.
The third case is from July 13th, 2025, case number 25 CR 6781C. You have 2 charges for battery, family violence and 3 charges for simple battery, family violence. Did you hear me?
You had 2 charges.
You said 3 what now?
You have a total of 5 charges. 2 are battery, family violence, and 3 are simple battery, family violence. This is from July 13th, 2025.
Okay.
So these are the 3 cases. And Miss Tucker has already gone over the recommendation from the prosecutor, which will require you to be on probation for up to 3 years, have no contact with Miss Greer, and stay away from her and her home and wherever she's located. Do you understand?
Yes.
All right. If you do not want to accept the plea, then you have a right to demand a jury trial. Your cases will be rescheduled for a jury trial where you will be represented by the Public Defender's Office. And at that time, when you show up in court, you will still be legally presumed innocent of all these charges. At the time of the trial, the prosecutor would have to carry his or her burden to prove all these charges against you beyond a reasonable doubt. If the prosecutor succeeds and overcomes your legal presumption of innocence, you could be found guilty of one or more of all these charges that I've listed to you. Each charge carries a maximum penalty of up to a year in prison and or up to $1,000 fine. Did you hear me?
It broke up a little bit, but
Where did you last hear me say?
Tell her the part that you did.
the last part I heard was if I'm found guilty. That's the last part.
If the prosecutor succeeds and overcomes your legal presumption of innocence, you could be found guilty of one or more of all the charges. Each charge will carry a penalty of up to 1 year in prison and up to $1,000 fine. Other conditions could still apply, such as no contact, stay away, anger management, a domestic violence program, community services, etc. Do you understand?
Yes.
Based on the information I provided, would you like to continue and have a trial in these cases?
I want to look into having another attorney so I can make the decision.
All right. We're going to reschedule this case to December 4th. Miss Washington, are you declining the services of the Public Defender's Office?
I'm not able to get another attorney with the Public Defender Office.
I'm going to reset it to December 4th. And if Miss Tucker is the attorney on that day, she will continue to represent you. Otherwise, you can hire your own attorney. Today is November 20th. You have till December 4th to hire your own attorney, unless you want to decline the service, if you decline the PD services. Thank you, Miss Milton. Deputy Milton, these cases are rescheduled to December 4th.
Thank you, Your Honor. Thank you, Ms. Tucker.
Officer Milton.
All right.
We still have to address position 6 at ACDC.
All right, Miss Greer, you're free to go.
I'll call you.
She'll call you.
Thank you.
Courtroom 2, next case, please.
Brenda, can we have a brief recess? vote?
Yes.
Okay,
I
thank you.
think Ms. Greenhouse also wants one.
All right,
Thank you. 5-minute recess, folks.
all right.
It's Siri.
Ms. Grace?
Call April.
Calling April. Mobile.
Grace, could you mute? Otherwise, we'll all listen to the conversation.
Your Honor, I have an announcement on one of my positions.
Which one?
Position 44 and 45 is gonna be an MH reset.
Okay. That would be,
Mr.
right, Miss Grace, please note Jonathan Williams, case 25 CR 4665D, and his bench warrant will be reset to December 4th. This will be an MH reset. And will he be getting a social worker visit?
Yes, Your Honor, I'll be requesting one.
All right, thank you.
Your Honor, we can go to position 36, Mr. Stafford.
36. Ferguan Rahman Stafford is accused of criminal trespass from November 6th of 2025. He is currently in custody on a $1,500 surety bond, case number 25CR 7132Y. Mr. Stafford, you've been advised of your rights. Your attorney is Ms. Tucker. Ms. Tucker, is this going to be a negotiated plea?
Yes, Your Honor, it will be negotiated, please.
All right. And Stafford. Mr. Stafford, please raise your right hand. For purposes of the plea, do you solemnly swear the information you provide will be the truth to the best of your knowledge?
Oh, yes, no.
I think I heard yes, Judge Law.
Yes, ma'am.
All right, good. You have a deep, resonant voice, and you just need to project it, but the mic can pick you up, okay? Mr. Scirocco, what is the recommendation?
Yes, Your Honor. On the criminal trespass, the state's recommendation is 12 months, serve 30 days, credit for time served, balance probated, BHET, stay away from Colonial Square Apartments, that is located at 2637 Old Hateville Road in Atlanta, and 30 hours community service. We ask that defense stipulate the factual basis, venue, and ID for purposes of the plea.
We do so stipulate for the purpose of the plea. And we will request that once he completes the terms, probation go not reported.
And no objection to that.
If I recollect, wasn't this a repeat offense?
Let me double check.
Who is this again?
This is Stafford, position 36.
Thank you. I stepped away. Thank you.
Yes.
It may well have been, Judge. I see a note that says a Miss Shoemaker criminally trespassed the defendant, which he acknowledged she could no longer return, although I'm not sure if that's in reference to a previous criminal trespass or not. Let me see.
All right, well, I'll accept the state's recommendation, but I'm just pausing because of the nature of the bond that triggered a memory about whether this was a situation of a repeat offense or an egregious circumstance. So anyways, Ms. Tucker, does your client accept these terms?
Yes, Your Honor.
Okay. Mr. Stafford, have you consumed any medicine or alcohol recently?
Oh, no.
And have you understood what's going on in your case?
Yes, ma'am.
And you understand that you'll have to stay away from the entire apartment complex referred to as Colonial Square in Hateville, Georgia.
Yes, ma'am.
Are you satisfied with your attorney? Are you satisfied with your attorney?
Yes, ma'am.
If you decide to plead guilty to this charge, you would have to give up your right to a trial. You will not be able to go back to face a judge or a jury, as well as your accuser. You will not be able to present your legal arguments and defenses, and the state won't have to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of criminal trespass?
Yes.
Your sentence is 12 months to serve 30 days, credit for time served. You'll report to probation on Monday before 3 p.m. where you will you will report to probation every month. At all times, you're to stay away from the Colonial Square Apartments in Hapeville, Georgia. Complete 30 hours of community service at any nonprofit agency at a minimum rate of 5 hours per month. Within 30 days, you will also seek out a healthcare provider and undergo a behavioral health and evaluation and treatment, and make sure that you comply with all treatment and medication. You're also to update your probation officer with a valid mailing address within 30 days of being released. Understood?
Wow.
All right, thank you.
Your Honor, you can go to position 37, Mr. Stevens.
Okay. Rashad Stevens. Morning. Case number is 25 CR 7177D, accused of battery from April 14th of this year. Mr. Stevens has been advised of his rights. His attorney is Ms. Tucker. And negotiated plea?
Yes, Your Honor.
Mr. Stevens, for purposes of the plea, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am, Your Honor.
Thank you. Mr. Sakura?
Yes, Your Honor. For the battery, the state's recommendation is 12 months, served 90 days, credit for time served, balance probated, MHET, 12-week anger management, no further contact with Carol Sharpton, stay away from 435 Central Avenue in Atlanta, and 40 hours community service. We would, as that defense stipulated, a factual basis, venue, and ID for purposes of the plea, and at this time, we'd like to sound for Carol Sharpton.
Ms. Tucker, do you so stipulate, and does your client accept the terms?
We do so stipulate, for the purpose of the plea, he does accept the terms, Your Honor.
All right. I have another question. Mr. Toussaint, Howard, is Mr. Stevens got 3 other cases? I don't know what their status are. Is he on probation or what's going on? I have 24 CR 6854D, 25 CR 1246D, and 25 CR 1445D.
I don't know. I have to look it up.
There is a petition to revoke probation pending in 25 CR 1445D. He pled guilty to criminal trespass causing damage to property on April 3rd, and the petition was filed on July 18th.
Your Honor, he did recently have a probation revocation hearing in which they reinstated his probation.
Okay. So I just want to confirm that he's still on active probation in at least one or more of these other cases. All right, then that would help. Okay, Mr. Stevens, have you consumed any medicine or alcohol?
No, ma'am, Your Honor.
Have you understood what's going on in your cases?
Yes, ma'am, Your Honor.
And are you satisfied with your attorney?
Ma'am, Your Honor.
I'm sorry?
Yes, ma'am, Your Honor.
If you decide to plead guilty to this new charge of battery, this will be another active probation case against you, and you'll be required to report every month. There will be no non-reporting, and there will be no early termination. Do you understand?
Ma'am, Your Honor.
How do you plead to, sorry, and has it been explained to you that if you decide to plead guilty, you would have to give up your right to a trial? You will not be able to go back to court, face your accuser, challenge the evidence brought against you, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights? Sorry?
Yes, ma'am, Your Honor.
How do you plead to one count of battery from April 14th, 2025?
Yes, Your Honor.
Your sentence is 12 months to serve 90 days. The sheriff will give you the credit for the time that you've been at the jail. And once you are released, you must report to probation within 48 hours.
Yes,
While on
ma'am.
probation, sorry?
I just said yes, ma'am, Your Honor.
Okay. While on probation, you will complete 12 anger management classes, and you must begin those classes within 30 days of being released. You are to have no contact with Carol Sharpton, and you are to stay away from 435 Central Avenue in Atlanta, Georgia. Whatever community service you're supposed to do in your other cases, this will be an additional 40 hours of community service. And this must be done at a minimum rate of 5 hours per month. You're also to undergo a MH evaluation and submit yourself to any treatment, counseling, and medication and be compliant. As I've stated, you will report every month for the next 12 months, less the time that you have served at the jail, and you must be up to date with your probation fees. Thank you.
Yes, ma'am, Your Honor.
Yes, she should be.
Next case. ACDC, who do we have?
This is position 6 and 7, Ms. Bryant.
Is that your client, Ms. Tucker?
Yes, Your Honor.
And how are we proceeding?
It'll be a negotiated placement.
Right?
Yeah. They'd agree prior to accepting no local plea for Ms. Bryant.
All right. Who is the prosecutor? Mr. Scirocco or Ms. Spear?
Ms. Spear, I do believe.
I didn't hear the name. I'm sorry.
Position 6 and 7, Aja Bryant.
That is mine, Your Honor.
All right.
The defense had asked for a NOLO. We said we would not object.
Okay. This is Aja Belaine Bryant, accused of simple battery and battery from September 7th, 2024, case number 25 CR 1075E. She also has a bench warrant from August 25th of this year, case number 25 FTA 2180. Ms. Bryant, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. Can you hear me all right? You need to speak up through your mask. Can you hear me all right?
Going in and out.
Dear, oh dear. Okay. Did you hear about your cases? All right. We are having a problem with audio at ACDC. Is Deputy Milton there?
Well, she won't go, but it's going in and out.
Miss Bryant, you are charged with battery and simple battery. Did you hear that?
Yeah, I heard.
The incident date is September 7th, 2024. Anytime you can't, Deputy Milton, we are having audio issues. Is there a problem with the monitor, or can we move to a different monitor?
Hey, Your Honor, this is Captain Baxter. Officer Milton actually, and I'm just here to assist, not really sure. So what are you having issues with? Can't hear, or?
Okay. All right, Miss Bryant, raise your hand anytime you can't hear me, okay? Can
Yeah.
you hear me right now?
Yeah.
You have a right to remain silent about your case. Anything you say can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you, and Miss Tucker is currently representing you. Do you understand?
Yes.
Have you decided to accept a plea offer from the prosecutor?
Yes.
Please raise your right hand. Do you swear the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Anytime you can't hear someone, you need to raise your right hand, okay?
Yes.
Ms. Spear, what is the recommendation for the battery and simple battery charge?
Yes, Your Honor. We are requesting 12 months probation, credit for time served. Stay away from Emory at 550 Peachtree Street, MHET. No further contact with Nurse Whitney Molina or Nurse Avisia Burks, other than medical emergency necessity. Count 2, we are requesting 12 months probation to run concurrent. We are null processing the FTA in exchange for the plea, and we would ask for a stipulation to ID venue and probable cause for the plea.
Ms. Tucker?
We do so stipulate for the purpose of the plea, Your Honor. And we would also request in this case that once she completes the terms, she be allowed to report it.
Repeat your last sentence. She did not hear you.
We're asking that once she completes the terms of probation, I'm sorry, once she gets the eval done, that her probation go non-reporting.
Okay. Miss Bryant, have you consumed any medicine or alcohol recently?
Yes, for the seizure
All
that
right.
I was having when I got to the hospital.
Are you able to understand us after consuming the medicine?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
Are you entering a guilty plea, a no-law plea freely, willingly, and voluntarily?
Yes.
If you decide to do so, you would have to give up your right to a trial. You will not get a courtroom, you will not go to the courtroom to face a judge, a jury, and your accuser. You will not be able to challenge the evidence and the charges brought against you. And the prosecutor won't have to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
If I'm getting ready to be released,
I'm sorry?
I'm still being released, or
If you want to have a trial, you can be released once you pay your bond.
I don't need a trial then.
Repeat? What did you say?
I was trying to do the time served.
So she's asking, do you want to go to trial or do you want to go for a plea?
The plea. I get to go home, the plea.
Are you prepared to give up your constitutional rights to a trial, as I've just listed them?
Yes, if I get to go home, yes.
How do you plead to one count of simple battery and one count of battery? Did you hear me?
Just guilty.
You look surprised. These are the two charges I've just read out against you.
Just guilty. That's the plea.
Ms. Bryan, we did discuss this yesterday, and you requested to plead nolo.
Yes.
State has approved that. I mean, they want
I'm going to repeat the question. How do you plead to one count of battery and one count of simple battery?
One count?
You have one count you have two charges. One is battery and one is simple battery. How do you plead to both of them?
Guilty.
All right, we'll take this as a guilty plea. The sentence is going to be 12 months, credit for time served. And will she be released within 24 hours, Ms. Tucker?
Yes, the state did not ask for any additional time to serve.
Okay. Once she is released, she will report to probation on Monday before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. Do you understand, Ms. Bryant?
Yes, ma'am.
While you're on probation, you will undergo a mental health evaluation with your healthcare provider and submit to all treatment and medication. Do you understand?
Yes, ma'am.
But you cannot return to the Emory Hospital unless you have an appointment or you're seeking a emergency treatment. You would need to go to another hospital because you cannot have any contact with nurses Molina and Burke. Understood?
Yes, ma'am.
Count 2 is going to be 12 months concurrent with count 1, and the bench warrant will be null prost. Thank you.
May we be excused, Your Honor?
Yes, thank you. Thank you, Deputy. Thank you.
Thank you.
All right, courtroom 2, who do we have, please?
Position 42, Mr. Wilburn.
Elijah Isaiah Wilburn is accused under case 25 CR 6172B. Mr. Wilburn, you've been advised of your rights, and your attorney is going to be Ms. Tucker. The charges brought against you is 1 count of simple assault family violence and 1 count of simple assault from July 12th of this year. Ms. Tucker, how are we proceeding?
This will be a negotiated plea, Your Honor.
All right. Mr. Wilburn, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Mr. Scirocco?
Thank you, Your Honor. For count 1, which is, as I noted, now simple assault family violence, there was an error with filing, and it's subsequently been filed down. Count 1 is simple assault family violence. Count 2, simple assault. On count 1, the state's recommendation is 12 months served 96 days, credit for time served, balance probated, undergoing complete FFIB, no further contact with Bridget Wilburn, and stay away from 3200 Cushman Circle in Atlanta. And count 2, the simple assault, 12 months probation concurrent with count 1, no further contact with Zakiya Glenn. I will mention we did speak with Miss, I believe it's Miss Wilburn here. Let me double check that that is the case. She stated she wants the defendant to get counseling or anger management classes. She also expressed that she wants the defendant to pay for the TV that was broken. However, we did not charge a criminal trespass for the damage to that property. So we won't be asking for that. I will note it was estimated at $198 according to her. She also wants the defendant to get his GED, get a job, and take parenting classes as well. We are hoping that the Family Violence Intervention Program will help with respect to parenting as well. If we could sound for Miss Wilburn and Miss Glenn at this time, and we would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea.
Zakiya Glenn and Bridget Wilburn. No, not present. Okay.
We do so stipulate for the purpose of the plea. Mr. Wilburn, just asked me about submitting a NOLO plea on this charge. Would the state be acceptable to that?
We would be fine with the NOLO with respect to the simple assault, not the family violence. Excuse me, I missed one thing at the end. Miss Wilburn is okay with no further violent contact, so we'd be fine with no further violent contact. Let me,
And no contact with Zakia Glenn?
Miss Glenn, is his minor sibling. Wilburn is his mother. So
Right.
I would assume if she wants contact, then he would be allowed to have contact with his 8-year-old sister as well.
Yeah, but we've obviously only spoken with Miss Wilburn, so
And
we'll
when
leave
does
that
the
to
parenting class kick in?
He is a father. I'm assuming his mother just wants that, but it's not relevant to the case at all.
I don't know. Is he a babysitter for the younger sibling?
I actually took care of her. So I wouldn't say babysitter, I would say, guardian,
Wow, do not.
partial guardian. I mean, yeah.
All right. Anything else, Mr. Scirocco?
nothing from the state judge.
All right. So, if your client wants if he wants to plead, it would be a guilty to the simple assault, family violence, and a NOLO to the simple assault. Is your client still like to proceed with the plea?
Yes, Your Honor.
All right, Mr. Will, and do you so stipulate, Ms. Tucker? I'm sorry, don't know if you did.
I'll stipulate for the purpose of plea, Your Honor.
Mr. Wilburn, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in your case?
Yes, to the best of my knowledge.
And are you satisfied with your attorney?
Yes, I am.
If you decide to plead guilty and nolo contendere to the respective charges, you would have to give up your right to a trial. You will not go back to a courtroom to face a judge or a jury as well as your accusers. You will not be able to challenge the charges brought against you, nor the evidence, not present your defenses and arguments, and the state won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, sir. Yes, Your Honor, I accept the plea.
I asked you whether you're prepared to give up your constitutional rights to a trial and all the other enumerated rights I've listed.
Yes, ma'am.
No? Was that a no?
Oh, I say yes, ma'am.
Okay. So
Oh,
how
and
do
we
you
will not
plead?
be, given the request for no further violent contact, we won't be asking for the stay away.
Okay.
All right.
How do you plead to simple assault, family violence involving Bridget Wilburn?
Guilty.
How do you plead to simple assault involving ZG, your sister?
No.
For the simple assault, family violence, your sentence is 12 months to serve 90 days. Was 90 days, correct?
96 days, Judge.
96 days, credit for time served. Once the sheriff releases you, you will report to probation within 48 hours of being released to the next available business day, which I think in this case is going to be, is it going to be Monday, Ms. Tucker?
Yes, Your Honor.
Okay, so on Monday, he reports to probation before 3 p.m. While he's on probation, he shall have no further violent contact with Bridget Wilburn, with his sister, and any other occupants in his home. He may return to the Cushman Circle location, and he will undergo one parenting class within 45 days of being released. Also, within 30 days of being released, he will enroll in a qualified domestic violence program and complete all 24 weeks of classes. It's once a week. Complete all classes without missing or skipping any of them, and he's to pay for them out of his own pocket. He reports to probation every month, and once he has completed the parenting class, he has completed the FVIP classes, his probation fees are up to date, and there are no further violations of the law. His probation may be non-reporting. Thank you.
Judge, can you repeat the guilty on each charge and the NOLO on the charge as well?
Guilty to simple assault, family violence, and NOLO to simple assault, count 2.
Thank you.
You're welcome. Courtroom 2, next case.
Your Honor, go to position 25, Mr. Jones, Anthony Jones, the first one.
All right. Mr. Anthony Jones has 2 cases before us, 25 CR 7182E.
Your Honor.
Yeah.
Oh, he only has 1 case. It's just there's 2 different Anthony Jones.
Oh, I'm sorry. Which one is he? Position
25.
25. Mr. Ahmed, is this your client?
Yes, Your Honor.
Just to confirm, his accusation number ends 25 CR 7182E. Is that correct?
Yes, Your Honor.
Okay. So this particular Anthony Jones is accused of 4 counts of battery family violence and 1 count of simple battery family violence from a September 24th, 2025 incident. Mr. Jones, you've been advised of your rights. Your attorney is Mr. Ahmed. And is this going to be a negotiated plea?
Yes, Your Honor.
Raise your right hand, Mr. Jones. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
No.
And Mr. Scirocco, are you all proceeding on all 5 charges?
No, Your Honor. It would be count 1 that we'd be proceeding on, the first battery family violence charge. The remaining counts of battery family violence and simple battery family violence, respectively, would merge with count 1.
Okay. And what's the recommendation for count 1?
State's recommendation for count 1 is 12 months to serve 28 days, credit for time served, balance probated, FFIP, no further contact with Geraldine Mason. Stay away from the 2 addresses that we have for her, being 552 Parkway Drive in Atlanta and 588 Paynes Avenue in Atlanta, as well as 60 hours community service. We would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea. I will mention as well, we did speak with Ms. Mason. She did express to us that she wants the charges dropped. It was explained to her that this is the state's case. We are proceeding on said charges. So that was explained to her. She understood that. So if we could sound for Ms. Mason, if she's online and wishes to speak, and that is going to be all for the state.
Geraldine Mason? No, she's not here. Yes, Mr. Ahmed. Any views or stipulate?
Yes, Your Honor. My apologies. It just brought to my attention that there might be a little problem with the negotiated plea as to the contact with Ms. Mason, given that the client has, I believe, a pair of twins on the way with Ms. Mason. We would just request no further violent contacts on top.
I think what I'll require him to do is file a legitimation case.
Yes, Your Honor.
And if he wants to have joint custody and joint visitation with the children, then as soon as they're born, he needs to file a legitimation case so that he can get a court-ordered parenting plan, joint custody and joint visitation. Unless he's married to Miss Mason. Were they married?
They were.
Are you married to Geraldine Mason? No? Okay. So that's the legal route to take. If you wish to be a part of the twins' lives, you need to file a legitimation case.
And Your Honor, could we just request third-party transport in the interim or?
No, file a legitimation case. That's how it works. All right. So stipulated, Mr. Jones, have you consumed any medicine or alcohol? Sorry?
No, ma'am.
And are you satisfied with your legal services?
Yes, ma'am.
And in your discussions with Mr. Ahmed, you understand what's going on in your case?
Yes.
And if you decide to plead guilty to this charge of battery family violence, that would go on your criminal history record. Any subsequent arrest of a same or similar charge can be a felony charge by law. Do you understand that?
Yes.
Are you still willing to move forward with this plea freely, willingly, and knowingly?
Yes.
If you decide to accept the plea offer, you would have to give up your right to a trial. You will not go back to a courtroom to face a judge or a jury, and you will not be able to confront your accusers. There will be no opportunity to challenge the evidence brought against you, present your own legal defenses and arguments, and the state won't have to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights? Sorry?
Yes, ma'am.
How do you plead to one count of battery family violence?
Guilty.
Your sentence is going to be 12 months to serve 28 days, credit for time served 14 days. I do see that you have an open case for 2 felony charges as well. Is that holding him at the jail?
I believe so, Your Honor. No? I think I'm waiting for bond. Oh, Anthony Jones.
I don't know if he's had first appearance because there's no bond set.
I went first, ma'am.
Did you?
Yeah.
I said you waived your appearance on there.
I went
He has a
first, ma'am.
preliminary hearing December. Right now. he-
Well,
So no bond? So no bond set, Your Honor.
okay. So as soon as you are released on your felony charges, Mr. Jones, you would have to report to Fulton County Probation within 48 hours on the first available business day. While on probation, you will complete a domestic violence intervention program. This is a series of 24 weeks of classes that you cannot afford to skip or miss, and you will pay for the classes out of your own pocket. You will have no contact with Geraldine Mason. So even though she wants contact, you are required by law to stay 200 yards away from her, not communicate with her in any way, form, or manner. And if you violate these conditions and the officers find out, you could risk your probation being revoked. As I said, if you wish to have an active participation in any child or children that you share with her, you would need to file a legitimation case and get a court-ordered parenting plan and a child support order. At all times, you have to stay away from 552, I think it was Penny Drive?
552 Parkway Drive in
Parkway
Atlanta
Drive,
and
okay.
588 Paynes Avenue in Atlanta.
You need to stay away from both locations. Are these both active addresses from the victim?
From what I can tell and what information I have, that's yes.
All right.
So
in addition to the FFIT classes, he will also be required to do 60 hours of voluntary community service. And this can be with any nonprofit agency that's not a church and not a school. He'll be required to complete his community service at a minimum rate of 10 hours per month. He will report every month, be up to date with his probation fees, and make sure that he complies with all conditions and not violate any future laws. Thank you.
You can go to position 2829, Mr. Reyes.
Do we need a Spanish interpreter for this?
Yes.
I know someone's been waiting very patiently. I appreciate that.
Yeah.
Miss Lucia, yes, let's see if she's available.
Your Honor, I'm here.
Thank you. Thank you for waiting. Appreciate it. This is 28 and 29. Lucia, do you solemnly swear and affirm the translation you provide will be true and accurate with no changes or embellishments?
I do.
Thank you. This is State versus Joaquin Obispo Reyes.
Este es el estado de Georgia en contra del señor Joaquín Obispo Reyes.
Mr. Reyes is accused of unlawful conduct during a 911 call from June 5th of 2025.
Está siendo acusado el señor Reyes de conducta ilícita durante una llamada al 911 de junio 5 del 2025.
He's got a bench warrant under case number 25 FTA 2183 for failure to appear in court.
Tiene usted una orden de captura, una orden de arresto bajo el caso 25 FTA 002183 por no haberse presentado el día de la fecha que tenía su corte.
Mr. Reyes, you have a right to remain silent. Anything you say about the case, your statements can and will be used against you.
Señor Reyes, usted tiene el derecho de permanecer en silencio. Cualquier cosa que usted diga podrá ser y será usada en contra suya.
You have a right to an attorney. If you cannot afford one, Mr. Ahmed is going to be representing you for this case.
Tiene derecho a tener un abogado. Si no puede costear su propio abogado, el abogado al lado suyo, el señor Ahmed, va a estar representándolo en este caso.
So, Mr. Ahmed, just to get a better understanding of the lay of the land, for this particular charge, he's got a $1,000 surety bond because of his failure to appear.
Para este caso, que por no haberse presentado, tiene un bono de fianza de $1,000 asegurados.
He's got a $10,000 surety bond on his outstanding felony charge.
Tiene un bono asegurado de fianza de $10,000 por el caso que todavía tiene pendiente de delito mayor.
So, what are we doing today?
Entonces la juez pregunta qué es lo que van a hacer el día de hoy.
Your Honor, today this is going to be a negotiated plea.
Y su abogado indica que este día ustedes tienen un acuerdo negociado.
Okay. Mr. Scaraca?
Yes, Your Honor. For position 28, the unlawful contact with 911 operator, the state's recommendation is as follows.
Y la fiscalía indica que para su caso en posición 28, que es la conducta ilícita durante la llamada al 911 e interferir con un operador del 911, lo que la fiscalía sugiere es lo siguiente.
12 months probation to serve 26 days, credit for time served, balance to be served on probation.
12 meses, una sentencia de 12 meses en probatoria. 26 días que ya han sido servidos van a ser acreditados y el balance va a ser todo ese tiempo bajo probatoria.
Defendants shall submit to a mental health evaluation and follow any recommended treatment.
Tiene que sujetarse a una evaluación de salud mental y seguir cualquier tratamiento que se le indique.
No calling 911 unless there is an actual true emergency.
No puede llamar al 911 a menos que haya una emergencia verdadera.
And 20 hours community service.
Y 20 horas de servicio a la comunidad.
We would ask that defense stipulate to factual basis, venue, and ID for purposes of the plea, and upon accepting the plea, the state will will dismiss position 29, the failure to appear.
Vamos a pedir que el acusado esté de acuerdo con la estipulación de los hechos en este caso, del lugar, la sede del caso y de su identidad. Una vez que usted esté de acuerdo y estipule a estas tres cosas, entonces la fiscalía está de acuerdo a ofrecerle ese acuerdo y a quitarle, anularle los cargos de la posición número 29, que es no haberse presentado.
All right, so that was balanced probated, MHET, no 911 calls, and 20 hours community service, correct?
That is correct, Judge.
Mr. Ahmed, are these the terms to which your client has agreed?
Yes, Your Honor, they are. We would just ask and request of the court to waive probationary fees for 3 to 4 month period for Mr. Obispo Reyes.
Ms. Lucia?
La jueza confirma con la fiscalía que lo que ellos quieren es el balance de los 26 días a los 12 meses en probatoria, evaluación y tratamiento de salud mental y orden judicial para que no llame al 911 a menos que sea una emergencia verdadera y 20 horas de servicio a la comunidad. En adición a eso, adicionalmente, su abogado defensor está pidiendo que le quiten los gastos de probatoria por 3 o 4 meses.
I will waive 2 months of probation fees, which will be 60 days. So because I don't know when he'll be released. But would your client still like to continue?
La juez indica que ella va a quitarle, anularle 60 días, 2 meses de los costos de probatoria porque no estamos seguros cuándo va a poder salir. ¿Está de acuerdo con continuar así? Yes.
Mr. Reyes, have you consumed any medicine or alcohol recently?
Señor Reyes, ¿ha consumido usted alguna droga o alguna bebida alcohólica últimamente? No, not today.
Have you understood what's going on in your case?
¿Ha entendido usted, ha comprendido usted lo que está pasando en su caso? Yes.
Are you satisfied with your attorney?
¿Está satisfecho usted con su abogado? Yes.
Okay, you'll need to speak a little louder so your interpreter can hear you as well.
¿Puede, por favor, hablar un poco más alto, en voz más alta, para yo poder oírle?
Sí.
Yes.
If you decide to plead guilty to this charge, you would have to give up your right to take this case to trial.
Al declararse culpable, en este caso, usted está renunciando a su derecho de llevar este caso a un juicio.
You will not be in a courtroom to face a judge, a jury, as well as those accusing you of this crime.
No va a llegar a un tribunal para encarar a un juez, a un jurado y a las personas que le están acusando de este delito.
The prosecutor also won't have to prove the charge against you beyond a reasonable doubt.
El fiscal entonces no tendrá que comprobar el caso que ellos tienen en contra suyo más allá de cualquier duda.
Are you prepared to give up these rights?
¿Está usted preparado para renunciar a esos derechos? Yes.
How do you plead to unlawful conduct during a 911 call?
¿Cómo se declara usted ante la acusación de conducta ilícita durante una llamada al 911? Guilty.
Your sentence is 12 months to serve 26 days, credit for time served 13 days. The balance will be served on probation once you are released from the Fulton County Jail due to your other case.
La sentencia es la siguiente. Es 12 meses con crédito para servir 26 días, crédito por los 13 días ya servidos, el balance en probatoria una vez que salga de la cárcel del condado de Fulton.
You will report within 48 hours of being released. And while on probation, you will do 20 hours of community service, a mental health evaluation, and submit to all treatment. And you're not allowed to make any 911 calls unless there is a bona fide or genuine emergency.
Una vez que salga de la cárcel, tiene 48 horas para presentarse a la oficina de probatoria. Durante el transcurso de tiempo que usted está en probatoria, necesita servir 20 horas de servicio comunitario, necesita someterse a una evaluación y seguir el tratamiento de salud mental y no puede llamar al 911 a menos que sea una emergencia verdadera.
I will waive your probation fees for the first 60 days, but then you start paying probation fees from the 3rd month onwards.
Le voy a quitar, le voy a deducir los costos de probatoria por los primeros 2 meses. A partir del mes 3, usted va a necesitar costear los gastos de probatoria.
Your bench warrant is dismissed.
Y se le anula la orden de arresto que tiene.
Thank you.
Gracias.
Right. Courtroom 2, is there anyone else who needs the services of a Spanish interpreter?
No, Your Honor.
All right. Do any of defense counsel need a Spanish interpreter for maybe an ACDC or any other case on the calendar?
No, Your Honor.
All right. Okay, Ms. Lucia, thank you so much for waiting. Sorry it took a little longer than required, but you have a great day. Thank you.
Thank you, Your Honor. Have a good day.
You too. All right, courtroom 2, next case.
Positions 23 and 24, Mr. Jonathan.
State versus Jonathan Robert Johnson's case is 25 CR 1962Y, and he's got a bench warrant under 25 FTA 2138. With regards to Mr. Johnson, this is 1 count of battery from April 13th, 2025. Mr. Johnson, you've been advised of your rights. Your attorney is Mr. Ahmed. And how are we proceeding? Is this a plea?
Yes, Your Honor, this would be a plea.
Okay, I'm sorry, folks. I'm going to have to keep asking you until my paperwork's all squared away. But it's, well, but anyways, Mr. Johnson, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Ms. Spear?
Yes, Your Honor. Just making sure that I have the right case. Okay, 12 months probation, served 10 days, credit for any time already served, balance probated, 12 hours of anger management, and 40 hours of community service. We will null pros the FTA.
All right. There isn't a no contact or stay away, correct?
There is not.
Okay, that's good. Mr. Ahmed, do you so stipulate, and does your client accept these terms?
Yes, Your Honor, we would just request non-reporting probation given that Mr. Johnson lives in LaGrange, Georgia.
All right. He'll need to report the first visit, which will be on Monday before 3 p.m.
Okay.
And as soon as he shows proof that he has enrolled in an anger management program, his probation may be non-reporting. And then he would need to show proof within this 12 hours. So that's going to be how many? 1, 2, 3. So it's going to be 3 months. So within 3 to 3.5 months, he'll need to come back to probation and show proof that he has completed all anger management classes. And he would need to show proof that he's completed all community service and his probation fees up to date. And then I will allow for non-reporting to resume. Would that Is that understandable, Mr. Ahmed? I've made it more complicated.
Yeah. Okay, yes, Your Honor.
Okay. All right. So Mr. Johnson, have you consumed any medicine or alcohol recently?
No.
Have you understood what's going on in your case?
That's not true.
And are you satisfied with your attorney?
Yes.
If you decide to accept this plea offer, you would have to give up your right to a trial. You will not be able to confront your accuser, challenge evidence brought against you, and the state won't have to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to one count of battery?
Guilty.
Your sentence is 12 months to serve 10 days, credit for time served, I guess, 10 days. Is that how long he's been in custody?
About days, I believe, Your Honor.
Yeah, I showed 2 days, but that was last week, so I think he's right about at 10.
Okay. I'm going to do serve 10 days, credit for time served 10 days, and he will be released within 24 hours. His first visit to probation must be in person, and then it will continue to be in person until he shows proof that he has enrolled in an anger management program. He will continue to report then by telephone, and about less than 4 months later, once he's completed his anger management classes, he has completed 40 hours of community service, and he has not violated any law and is up to date with his probation fees, then his probation will continue to be non-reporting. All right? Okay, the bench warrants null pros. Thank you.
Thank you, Your Honor. Yeah. Okay.
Next up is position 26, Mr. Jones. Anthony Jones.
Oh, the other Jones. Okay.
Yes, ma'am.
Yes, Your Honor.
Excuse me. This is 25. Let me just grab a glass of water. I'll be right with you. All right, thank you, Beth. 26 is State versus Anthony Jones under accusation number 25 CR 7213A. And for this particular case, Mr. Jones is accused of simple battery, terroristic threats and acts, and simple battery against a police officer from November 6 of 2025. Mr. Jones, you've been advised of your rights, and your attorney is going to be Mr. Ahmed. You've been advised, and if this is going to be a negotiated plea or something else?
Your Honor, it's gonna be a non-negotiated plea. I can give the grounds if.
Understood. So let me just go ahead and place your client under oath for the plea. Mr. Jones, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. All right, this is a non-negotiated plea, so the state will first allocate the terms and the reason for the terms, and then the defense will respond. Mr. Scirocco?
Thank you, Your Honor. So this incident was from November 6th. This was at MARTA station in Atlanta. There was one at the Midtown MARTA station at 41 10th Street Northeast, Atlanta, and the Yeah, law enforcement had responded after the defendant was initially detained at Midtown MARTA station. He was sitting in the back of the MARTA police vehicle. At the Midtown station, the defendant there spit through a cracked window onto Officer Kirby's forehead and was then transported to police headquarters where, while being placed in the seatbelt, um, in transport, the defendant who was wearing a spit mask, then nonetheless intentionally spit on Officer Harris. And then the defendant also, the second time here, stated he was going to kill Officer Harris, and that Officer Harris was a marked man. The I'll give the recommendation in a second, but I do want to explain that the counts are listed out of order on as they're populated on Odyssey. Count 1 is the simple battery against a police officer. Count 2 is the simple battery, and count 3 is the terroristic threats and acts. But the defendant has roughly, it looks like 88 cycles. There was a disorderly conduct amended from terroristic threats and acts, of which he was convicted in 2024, another disorderly conduct conviction in 2018, a number of other charges, aggravated assault and criminal trespass conviction from 2020, aggravated assault conviction 2017. There's a older terroristic threats and acts conviction, felony, 2011, and also recent arrest for battery in 2023 and 2018. There were also a number of probation violations. 2023, two in 2023, one in 2022, another in 2021, and then there's another one in 2012. Additionally, it looks like there is a presumably open case out of Cobb for which he was indicted in 2024 for felony theft by shoplifting, criminal trespass, and willful obstruction. So, with that basis here, the state's recommendation, given the lengthy, significant criminal history and offenses involving law enforcement and violent offenses not involving law enforcement, the state's recommendation on count 1, the simple battery against a police officer, is 12 months probation, concurrent with count 3, 60 hours community service. Count 2, the simple battery, would merge with count 1, and count 3, the terroristic threats and acts, 12 months served, 60 days, credit for time served, balance probated. We are requesting MHET, 8-week anger management, stay away from the Lindbergh Center MARTA station at 2420 Piedmont Road, as well as the, I should have added the MARTA train station at 41 10th Street Northeast in Atlanta. We would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea.
So stay away from Lindbergh, which is the main hub,
Right.
and stay away from 10th Street MARTA station, which is what? Not Civic Center. I can't remember.
It's the Midtown station.
Midtown station. All right, and then count 2, the simple battery is going to merge with simple battery against an officer, correct?
That's correct, Judge.
Okay. Mr. Ahmed?
Yes, Your Honor. As to this plea, the reason why we're not taking that the state's plea or the state's offer is due to the conditions of time to serve, as well as the cost that would be associated with the anger management class, and also the time and transportation issues as well with the 60 hours of community service. So the main reason we'd cite to this, Your Honor, is for the fact that Mr. Jones is the main financial provider for his family of 3 kids, and that he does need to get out. He did bring up to me, Your Honor, that he would be open to serving weekends if that's an availability with this court, Your Honor.
Anything else, Mr. Ahmed?
Your Honor, just a moment. Yes, Your Honor, that's it.
I'm sorry, was there something else?
No, Your Honor.
So he is residing somewhere where he looks after 3 children. Is that what you're telling me?
Yes, Your Honor.
February 13th, 2025, he was booked into Fulton County Jail for theft by taking and certain violations of the train. True, he was dismissed. Then 6 months later, he came back on a theft by shoplifting charge and served 45 days. I don't know who was looking after the kids then. Then he came back on November 7th, not only on these charges. Yeah, these were, oh, and then he had a false report of a crime as well. And what happened to that charge? Is that is that a felony case?
It's a misdemeanor, Your Honor. I believe it's just gone up for bond.
Yeah, I believe yesterday you got a $10 cash bond on that charge.
Oh, okay. So now he's got another open case that we're dealing with. All right. If he wants to serve 6 months at Fulton County Jail, I'll accept that. But I'm not taking any weekend time, and he'll be banned from MARTA for the next 12 months. He'd be required to do the 60 hours of community service. No, well, 6 months in jail. He's already served 14 days, so he has about 5.5 more months to go. Otherwise, I think we should go to trial because the recommendation the defense recommendation is just to way too outrageous, given his arrest record, given the allegations and so forth. All right. Shall we consider this on December 4th or Mr. Ahmed?
Your Honor, just one more moment.
'25 CR 74. Miss Grace, is that 25 CR 007-480?
I have Y, Judge.
Why?
Yeah, the false
The
report.
false report, okay.
And
Yes,
Your Honor,
Mr. Ahmed.
Your Honor, we would just want to reset it to December 4th.
All right, case reset to December 4th. And Miss Grace, we are going to reset this case as well as 25 CR 007-480Y. Please make a note that I have denied the defense recommendation.
Repeat the number again, Judge.
Oh, the second case is 25 CR 007-480Y. And if it's not me on SAP, please make a note that I've already denied this defense recommendation on the negotiated plea.
Okay.
Thank you.
Next is 27, Mr. Metz.
Was that number 7, please?
27.
27, okay.
Your Honor, while we're handling this, if I could get put a breakout room with Miss Lowe, and then when I'm done with her, go with
Oh, the bench warrants? Okay. The folks who are here for a bench warrant, please start your video. All right, Jeremiah Pearson. Mr. Pearson, we're going to put you into a breakout room. And if nobody joins you in the next few minutes, don't get worried. We haven't forgotten you. We're just going to make sure that a defense counsel is available to speak with you. Okay?
Put, go ahead and put me in there with him. So, I mean, you won't have to
All
wait.
right. So take your hat off, Mr. Pearson. You're in court. All right. So there you go. Thank you. Miss Grace, please place Attorney Tom White and Jeremiah Pearson in one of the breakout rooms. All right, Topeka Lowe, you need to go to your closet and put on a jacket that is inappropriate wear for, yep, good idea. Thank you. And then later we'll put her in a breakout room with Mr. White. Thank you. We have State versus Antonio Quinton Metz, 25 CR 7201A. Mr. Metz, you have been charged under this accusation with 1 count of fair evasion, 1 count of criminal trespass, and you've been advised of your rights. Your attorney is Mr. Ahmed. And how are we proceeding, Mr. Ahmed?
Your Honor, this is gonna be a non-negotiated plea.
All right. Mr. Metz, please raise your right hand for the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? All right, thank you. Ms. Lowe, you're going to have to wait until Attorney Tom White is available to speak with you. So you can switch your video off while you're waiting. Thank you. All right, Mr. Scirocco, what's your recommendation for Mr. Metz?
Yes, Your Honor. On count 1, the fair evasion, 12 months probation concurrent with count 2. And count 2, the criminal trespass, would be 12 months served, 28 days, credit for time served, balance probated, BHET, stay away from all MARTA premises and property, and 30 hours community service. This was the November 7th criminal trespass at the Hamilton E. Holmes MARTA station, located at 70 Hamilton E. Holmes Drive in Atlanta. Officer witnessed the defendant sneak in like behind someone through the fare gate without paying the fare. And when stopped, it was found that upon a GCIC check, that the defendant actually had a permanent ban from MARTA that was issued on March 6th of this year, going into effect on April 6th of this year. And that was on a prior case involving vandalism and disorderly conduct towards an officer. The defendant nonetheless returned here. He has 49 cycles, including multiple prior convictions for criminal trespass from 2024. 2024 was a NOLO, I will say that. 2019 criminal trespass conviction, and another NOLO for criminal trespass, 2011. But he was more recently convicted of terroristic threats and acts, simple battery against a person who's 65 years or older, or a pregnant person, and willful obstruction. Other convictions for simple battery and disorderly conduct dating back as well. Probation violation 2024. And yes, that is what I have for this case. That's the rationale behind the state's recommendation. And we would ask that defense stipulate to factual basis, venue, and ID for purposes of the plea.
Okay. Mr. Pearson, have you already spoken to Attorney Tom White? Miss Grace, is Mr. White in a breakout with Miss Lowe?
Yes, he said that he was going to contact me with my attorney.
Okay, so go ahead and mute your screen and switch your video off until we're ready to address you. Thank you. Yes, Mr. Ahmed, and what is the alternative recommendation for Mr. Metz?
Your Honor, we're amenable to all the grounds except for the community service. I think it was a 30 hours community service. Your Honor, actually at the time, Mr. Metz was going to Grady. He just recently, or a little while ago, but it's still very much feeling the effects of quite an extensive leg surgery. And because of that surgery and because of that disability, he's actually going on disability for that. But he can't really be on his feet really whatsoever for any long period of time. So for those reasons, we would just request that the community service is removed, to make it more accessible for Mr. Metz.
Okay.
There's
In
sedentary
alternative to the
community
community service, it will be typically it will be a $300 fine, because those are I typically switch a fine to community service. Otherwise, it'll be a $300 fine, and he can pay it at $30 a month.
And there is community service that can be done sedentary.
Your Honor, given Mr. Metz's financial situation, it's been indicated that he can do the community service sitting down if that's an option as
Oh,
product.
that's definitely available. He just needs to tell the food bank, he needs to sit down, or he can tell Goodwill he needs to sit down. I've seen people in wheelchairs work in Goodwill.
Okay, then that works. Thank you, Your Honor.
All right. And Mr. Metz, have you consumed any medicine or alcohol recently?
Blood pressure.
All right. And after consuming it, are you still able to understand what's going on?
Yeah.
Sorry?
Yes, ma'am.
And are you satisfied with your attorney? I can't hear you, sir. And our court reporter needs to take down whatever you say.
Yes, Your Honor.
Okay. If you decide to accept this plea offer, you would have to give up your right to a trial. You will not go back to a courtroom, face a judge or a jury. You won't be able to confront your accusers, challenge the evidence brought against you, and present your own defenses. And the prosecutor won't have to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to fair evasion and criminal trespass at Martyr?
No law.
That's not an option.
Say it again.
I'll plead guilty.
Your sentence for fair evasion is 12 months concurrent with count 1. For the criminal trespass at Martyr, your sentence is going to be 12 months to serve 28 days. Credit for time served 14 days. The remainder of the time you'll be on probation. You will report to Fulton County Probation on Monday before 3 p.m. Within 30 days, you will submit yourself to a healthcare provider and undergo a behavioral health evaluation and submit yourself to any treatment that's required. You'll also complete 30 hours of voluntary community service at any nonprofit agency. It cannot be a church and it cannot be a school, but it can be another organization that has religious affiliation, like Salvation Army or something like that. But, and as indicated, you can definitely obtain a community service in a sedentary position. You are to complete your community service at a minimum rate of 5 hours per month. At all times, whether now and forever, you are not to be on any Martyr property. You have a permanent ban. So unfortunately, you cannot step into any Martyr station, any Martyr bus, train, their facilities. You cannot use their bathrooms, their parking lots, and you cannot be on their sidewalk. Do you understand?
Yes.
All right. If you return to any Martyr property in violation of this of this sentence, your probation could be revoked. Thank you.
Next, our positions 34 and 35, Mr. Smith.
Briefly, Judge, while we're waiting on Mr. Smith, Mr. Pearson actually is represented by Miss McLeod. I didn't notice that until we got in the out. I am ready with Miss Lowe when you're ready. So just let
All
me
right. Please hold.
My sincerest apologies. I completely slipped my mind. I just wanted to request a waiver of probation fees for a couple of months until Mr. Metz can get his disability up and running.
All right. I will waive his probation fees for the first 2 months. So it'll be 60 days of fee waiver.
Thank you, Your Honor.
Okay. 34 and 35, that would be Martin Antoine Smith. Mr. Smith has a case 21 CR 3242Y. He's been advised of his rights. His attorney is Mr. Ahmed. And the charges under this accusation is criminal trespass, battery, and simple battery from June 11th, 2018. This case has not been addressed. It's been dormant, and a bench warrant was issued against Mr. Smith in 2021. So he currently has an FTA under 25 FTA 002185. Mr. Smith, you've been advised of your rights. Your attorney is Mr. Ahmed. And how are we proceeding, Mr. Ahmed?
Your Honor, we just have one issue with the state's offer. That's it.
What's the issue?
The issue is with the stay away order, as it's currently where Mr. Smith currently lives.
Well, it happened in 2018, so let's see what the state has to say. Mr. Scirocco?
Yes, Your Honor. This was a 2018 case. The victim here, whom law enforcement made contact with, is Miss Fatou Najiye. She explained that the defendant was involved in the incident. He damaged her iPhone and picture frames without her consent, and he broke both with his hands, and also pulled her hair and dragged her by her hair across the floor, causing visible lacerations to her, one of her knees and her ankles. The state's recommendation here on count 1 is 12 months probation concurrent with count 2. Stay away from 2840 Martin Luther King Jr. Drive in Atlanta. On count 2, the state's recommendation is 12 months served, 26 days credit for time served, balance probated, 12-week anger management course, and no further contact with Fatou Najiye. I believe that's the correct pronunciation there. Count 3 would merge with count 2. And just briefly, want to make sure we weren't able to, I don't believe we were able to reach Ms. Najiye recently, so let me just check.
I can lift the stay away as long as Ms. Najiye doesn't live at the property. So there can be a one-time visit with the officer to verify that Fatou Najiye does not live at the property, unless I have a different picture. So let me know, Mr. Ahmed, if that's the situation, because Mr. Smith has other issues at the present time.
And that's fine with the state judge. We would just ask that the court sound for Ms. Najiye if she is on and wishes to speak. And we would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea.
Yes, Your Honor. To our knowledge, Ms. Najiye doesn't live there, and I don't believe has lived there for quite some 3 years. And we would stipulate.
Okay. All right, Mr. Smith, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in this case?
Yes, ma'am.
Are you satisfied with your current counsel?
Yes, ma'am.
If you decide to plead guilty to these charges, 2 of them, you would have to give up your right to a trial. You will not go back to a courtroom to face a judge or a jury in state court. You will not be able to challenge the evidence brought against you, confront your accuser, present your own defenses and arguments, and the state won't have to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of criminal trespass and 1 count of battery?
Yep.
The simple battery charge will merge into the battery charge. The criminal trespass, the sentence is going to be 12 months probation concurrent with count 2. For the battery charge, is going to be 12 months to serve 26 days, credit for time served 13 days, balance probated. You will report to probation when within 48 hours of being released, and you will report to probation on the first available business day. While on probation, you will complete 12 anger management classes you must enroll within 30 days of being released, and you are to have no further contact with Fatou Najiye. can have a one-time visit to 2840 Martin Luther King Jr. Drive in Atlanta, Georgia. The first visit must be with a police officer. And once the officer verifies that Ms. Najir does not live or reside at the property, then you may return to that location. But if she continues to reside there, then you need to stay away from there until she voluntarily vacates the premises or you file the appropriate dispossessory action. Unfortunately, he's got 25 PI 009255. He's currently in a no bond status. So this case, this probation will remain in status until Mr. Smith is released and can fulfill his probation requirements. Any questions, Mr. Ahmed?
I mean, what's really going on? I thought that case was with this.
Oh, and the bench warrant is null pros.
That's correct.
Thank you, Ms. Grace. All right, while we are waiting for Mr. Ahmed, Ms. Topeka Lowe, and her case is 23 CR 004146C. Ms. Topeka Lowe, you'll need to start your video.
Good morning.
Morning, please. Well, it's already afternoon, but that's unless you're in a different time zone. But Ms. Lowe, you'll need to start your video.
I'm trying to start. Okay, there I go. There I go.
Topeka Lowe is accused of battery, family violence, and cruelty in the third degree from July 2nd, 2023. Ms. Lowe, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and I understand if you cannot afford one, one will be appointed to represent you, and Mr. Tom White has been speaking with you. She received a signature bond back on July 4th, 2023. She's had at least 3 court scheduled dates, and then the last one was October 10th, 2025, in which there was a failure to appear and a bench warrant was issued by the Honorable Judge Dixon. All right, Mr. White.
Your Honor, she didn't receive notice for this actual court date. She had received notice prior. She found out as soon as she found out that she did miss the court date, though, she went and checked. Her address has not changed in that time. We're not sure why it didn't get there, if it actually wasn't sent or the mail or whatever. But at any rate, it's the first time she's missed court on this case, and we're just asking the bench warrant be set aside. And I do have her address, and we just want to make sure that it hasn't changed, but just to make sure that we are all on the same page. I do have
I have
address.
Fairburn Road, apartment Q10.
That is correct.
Okay. And Mr. Scirocco, any objection?
I would say that I don't see a return to sender notice on file. Do we know what the issue was?
That she didn't get it. No. I mean, I can't tell you if the mail lost it, if it didn't get put in the right box, if it was actually really sent. I mean, but point is, it's the first time she's missed, and she said she didn't get notice. So.
All right. No objection.
The motion to set aside the bench warrant is granted. Ms. Lowe, this is a one-time only. Please, you've been very good about appearing in court otherwise. So please make sure that either you check with the U.S. Postal Service or check with your mailroom or however you receive it, to make sure that you keep up with your court dates. Good luck. Thank you.
Thank you.
White, please send in the proposed order. Thank you.
Thank you.
All right. Jeremiah Pearson, please unmute and start your video. This is Jeremiah Pearson, case 23 CR 53408. Mr. Pearson was originally charged with battery, family violence, and disorderly conduct from September 1st, 2023. Mr. Pearson, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, Ms. Maureen McLeod is your counsel. Ms. McLeod, have you been his counsel at all times, or is this a new thing?
Your Honor, I have been his counsel for quite some time. I did not actually know that he was on the calendar this morning until I heard Mr. White say that. So I essentially was not prepared for this. I was on the calendar waiting on another case.
Well, looks like back in January 30th of this year, there was a waiver of arraignment and further notice for trial. Yes, Ms. McLeod?
Yes, and that was filed by me, I believe, because it is my practice to waive arraignment on behalf of my clients.
Okay, and this was a failure to appear before Judge Roth on April 1st. Any particular reason?
I do not know if there was a situation where his address had not been changed in the system, Your Honor, because sometimes the information that I have, that my clients change their information and I don't get it, so I don't know what happened to him.
And what is your client's current address?
Mr. Pearson, what is your current address?
It's 302 Laura Ave, Southwest Atlanta, Georgia, 30310.
Unit number?
Unit 1563.
And Mr. Pearson, do you have my contact information?
Yes.
Okay.
I was given your contact information due to the nature of the case because I was calling the courthouse to see when do I go to court, and that's when I came notice of the bench warrant, and that's when I did the rescheduling and everything.
I'm a little puzzled. He filed an address change on October 13, 2023 to East Fayetteville Road in Riverdale.
Yes.
But you still have the previous address.
Well, I'm
confused. Which one is your right address?
Okay, when I got the nature of this charge, when I got arrested, I was not allowed to go back to my previous was 1475. So I ended up staying with a friend at the East Fayetteville, the 1155. When I moved from there to this location, the 302 Laura Avenue, that's when the mix-up came in with the change of address or not receiving notice for court to appear to court.
All right, Mr. Scirocco.
I will mention I don't see a return to sender notice on file. And I would say that, I mean, he knows that he needs to submit an address change clearly based on his prior having done so, in which he did receive notice, went to court from that different address, but I don't see a history of FTAs within the past couple of decades. So the state would be fine with lifting the bench warrant for on this one occasion.
Ms. McLeod, I'm going to set aside the bench warrant. Any changes in address, Mr. Pearson must immediately come down to the courthouse like he did in 2023 and update us in writing. Otherwise, we might be ending up in this sticky wicky situation again. All right?
Thank you, Your Honor. And Mr. Pearson, would you please send me your current contact information? You can either email me or you can send me a text message. That will be fine.
Okay, I got your number and I also have your email address still.
Awesome. Please, and if you do change anything, you need to let me know, okay?
Yes, I will, definitely.
Thank you.
Thank you. Thank you, Ms. McLeod.
You're welcome.
Ms. McLeod, I think you have to stay from 11 a.m.
I do, Your Honor, but I do have a trial, a bench trial for 1 o'clock.
Okay, understood. Could I put you in a breakout with Fern Guest so that you can just keep him up to date? with
Yes,
whatever
Your Honor.
information you're willing to share?
Yes,
Okay.
Your Honor.
All right, Mr. Pearson, you're free to go. Fern Guest. Miss Grace, once Fern Guest responds, could you place him in a breakout with Miss McLeod, please? Thank you. All right, Mr. Ahmed, what have we decided with regards to Mr. Smith, right?
We're proceeding with what we discussed, Your Honor, just with the subtraction of.
No, the last thing we left off with was the fact that he cannot report to probation until his felony matter has been resolved.
Yes, Your Honor, we discussed the felony matter. I went over the Odyssey logging for that as well, and as well as his upcoming hearing, so.
So he's staying with the plea, right?
Yes, Your Honor.
Okay, thank you. That concludes this case then. Thank you. And probation just needs to know that he cannot report until his felony matter is resolved. Thank you. Do we have anyone else to address in courtroom 2? I see one gentleman back there.
Yes, Your Honor. Positions 19 through 22.
All right.
Mr. Jakes.
Mr. Pearson, if you wish to stay and observe, please switch your video off.
Courtroom 2 is position 4, Mr. Allen going to be here?
I'll give you a call, Mr. White.
Okay.
All right.
Excuse me, Judge, before we start position 11, they have reset for 11/27, which is Thanksgiving. So can we clear that matter up?
Tyon Daniel, who represents him?
That was the case that was approved for felony transfer, Judge.
Oh, okay. That case is transferred to the Superior Court, so we're not resetting it. I think Mr. Scirocco has submitted the proposed orders.
And what about position 12, Evanston?
Oh, you can reset it to December 4th, pending transfer if you want.
12 is a waiver.
Thank you, Mr. White.
12 is a wait. Okay. So this one we have Mr. Kevin Jackson, who is presently in court. I'm sorry, positions 19, 20, and 21. So on position 19, Mr. Kevin Jackson is accused of battery from, this was from September 2018 under case number 19 CR 6081G. Under position number 20, Mr. Jackson is accused of obstruction of a law enforcement officer, misdemeanor possession of marijuana, and public drunkenness. And this is from November 20th, 2019. Under case number 19 CR 9498G. And his third case is from October 4th of 2024, in which Mr. Jackson was accused of willful obstruction of a law enforcement officer. Mr. Jackson, with regards to these 3 cases, you've been advised of your rights, and your attorney is Mr. Ahmed. And how are we proceeding, Mr. Ahmed?
Your Honor, this is gonna be a negotiated plea.
Thank you. And Ms. Spear, what's the recommendation for these 1, 2, 3, 4, 5 charges?
On case ending in 6081.
Yes.
Count 1, 12 months probation, serve 30 days, credit for time served. The balance probated. Family Violence Intervention Program, 40 hours of community service. No further contact with the victim, Susan Drew. Count 2, 12 months consecutive to count 1. In case
I'm
ending,
sorry, which one is consecutive to count 1?
the simple assault to the battery.
Kevin, under 6081G? I thought I only saw battery. Did I miss another charge?
There's simple assault on there as well, Your Honor.
Yeah, I'm sorry, I do see it now. Okay.
Okay.
So the simple assault is 12 months consecutive.
Consecutive, yes, to count 1. That's correct.
Count 1. Okay.
Okay, case ending in 9498G, obstruction, 12 months probation, the statutory $300 fine.
Mhm.
The marijuana, 12 months probation concurrent. There's also a public drunkenness on there that is credit for time served.
All right.
Case ending 6865, obstruction of a law enforcement officer, 12 months probation suspended. And we have agreed to null pros the FTA in exchange for the plea to these other cases.
Okay.
Oh, and we do request stipulation to ID venue and facts for the plea.
Mr. Ahmed?
Yes, Your Honor. This is, as I discussed with Mr. Jackson yesterday, this is stipulated.
I'm sorry?
This
You
was
do stipulate. Okay. All right. Just trying to figure out the time served over here. So,
I show he had 29 days from July 17th to August 14th. So he should have all his days done.
okay. On the obstruction where you said it's 12 months probation, credit for time served, balance suspended, I have 124 days. Is that correct?
I believe you, Your Honor.
So, excuse me, Judge, that was gonna be my question. Should it just be a flat time serve, or is this balance
That's
because of how
what
they're
I'm
doing it now?
trying to figure out. So it looks like oh, so sorry. On October 4th, 2024, he had served 2 days on that one. So I'm going to assume that's time served. Okay.
Yeah, we'll agree with that, Your Honor.
Okay. On the obstruction of a law enforcement officer from 2019, that was the one where he was in custody for 124 days. And then on the battery charge, he was in custody for 30 days. Okay. Mr. Ahmed, if you have if there are any discrepancies with the times I've listed, I'm just really literally going off the jailing screen for Mr. Jackson. All right, so Mr. Jackson, have you consumed any medicine or alcohol recently?
No, Your Honor.
And have you understood what's going on in all your 3 cases since 2018?
Yes, Your Honor.
And are you satisfied with your attorney?
Yes, Your Honor.
I'm sorry?
Yes, Your Honor.
If you decide to plead guilty to these charges from these 3 cases, you would have to give up your right to a trial. You will not go back to a courtroom to face your accuser, challenge the evidence brought against you, and be able to have the state prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to 1 count of battery under case 19 CR 6081G?
Guilty.
How do you plead to the obstruction of a law enforcement officer, misdemeanor possession of marijuana, and public drunk from, okay. And how do you plead to the 2024 charge of willful obstruction of a law enforcement officer?
Guilty.
For the battery charge from 2018, that's going to be 12 months probation to serve 30 days, credit for time served 15 days, balance probated. If you have no other holds at the Fulton County Jail, you will report to probation on Monday. Well, it looks like he's got a, oh, I see. All right, sorry. You will report to probation on Monday before 3 p.m. And while you're on probation, you will enroll in a domestic violence intervention program, complete 40 hours of community service at a minimum rate of 5 hours per month, and have no contact with Susan Drew. On count 2, the simple assault is going to be 12 months consecutive, which means you have an additional year of probation added to count 1. If you complete your domestic violence classes, satisfactorily, all 24 of them. You complete 40 hours of community service. You do not have any future violations of the law, and you are up to date with your probation fees, then your probation for count 2 will be non-reporting. For the charges from 2019, the obstruction of a law enforcement officer will be 12 months probation concurrent to the 2018 case, where you'll be required to pay a $300 fine. The misdemeanor probation of marijuana is going to be 12 months probation concurrent to count 1. And the public drunk is going to be time served 124 days. With regards to position 21, the willful obstruction of a law enforcement officer from 2024, that's going to be 12 months probation to serve 4 days, credit for time served 2 days, balance suspended. And the bench warrant will be null prost. So please report to probation on Monday. Thank you.
Thank you.
All right, I've addressed the bench warrants. We've addressed, I think, all the cases on the SAP calendar. Ms. McLeod, I promised you I will get you to your 1 p.m. Miss Grace, can you go over the calendar for the attorneys at the present time?
We have one more left, position 4. He should be down any second.
Okay, we'll just go over the calendar while we wait. Thank you. All right, Miss Grace.
On the DV calendar, both cases was reset, bench warrant withdrawn. Position number 1, 2, and 3, reset jail jury. We're holding on position number 4. Position number 5 was a plea. Position number 6 was a plea. Position 7, null pros. Position 8 and 9 were released. Position 10 was a plea. Position 11 transferred to Superior Court. Position 12 reset jail jury. Position 13 reset jail jury. Position 14 reset 12 to SAP. Position 15 was a plea. Position 16 reset jail jury. Position 17 was a plea. Position 18 transfer Superior Court. Position 19, 20, and 21 were pleas, with position 22 being null pros. Position 23 was a plea. Position 24 null pros. Position 25 was a plea. Position 26 reset 12 for SAP. Position 27 was a plea. Position 28 was a plea. Position 29 was null pros. I don't have anything for position 30. Mr.
Lamar Poss, what are we doing?
Your Honor, he was SOS, so he'd be a medical reset.
Okay, this will be a reset to December 4th. SAP. All right, Robert Powell. 31.
Position 31, reset further notice, defendant was released. Position 32, reset 12-4, SAP. Position 33, reset jail jury. Position 34 was a plea. Position 35 was a null pros. Position 36 was a plea. Position 37 was a plea. Position 38, reset further notice, defendant was released. Position 39, reset 12-4, SAP, along with 40, 41, position 40.
Yeah, that was it, yeah.
Was a plea. Position 43 was a plea. Position 44, reset 12-4, along with position 45. Position 46 was a plea. Position 47 was null pros. Position 48 was a plea. Any questions, concern, or comment?
All right. Thank you, Ms. Grace. I appreciate it.
No problem, Judge.
Okay, let's find out what's going on. Is Mr. Bartell available in courtroom 2? Okay.
Yes, Your Honor.
Yes, Your Honor. Miss Champion, could you please stop the live stream and the recording?